59. Huh. You write Mr. P.N. Sharma is present for the appellant. TCR not received. Let the matter be listed in the first week of August. Hmm.
To mention active number 12 and 13.
Huh?
12 and 13.
Huh.
Maybe kindly taken after 2 weeks. After 2 weeks.
Why? The bail application, why 2 weeks?
No,
What, 12 and?
Admission matter.
What's admission matter? 12 and 13. Okay, on the prayer of the learned counsel, on the prayer of Mr. R. Ali, H.A. Ahmed, the learned counsel appearing for the petitioner, let the matter be listed after 2 weeks. 12 and 13. Interim order so passed earlier shall continue till the next date of listing.
Maybe listen, Lordship.
Hmm.
Item number 49, man.
Huh?
49.
49.
For external.
49.
Fix on after 1 week.
49 on the prayer of the learned counsel. Your name?
A Khalek.
A. Khalek. The matter is adjourned for adjourned and to be listed after 2 weeks. After 2 weeks.
Obligement.
Hmm? 49 is bail hearing, huh? Recent IB application CD is received. Why do you want to do it after 2 weeks?
My senior is out of station. My senior out of station.
Who is your senior?
AZ Ahmed.
It cannot be, after 2 weeks, let it be listed on 4th of July, 4th of August. CD will go back, it will be a problem for you. When is he coming? When is he coming? Your senior.
2 weeks after 2 weeks.
2 weeks, how can AB application can be, CD has come already.
Day after tomorrow.
Day after tomorrow is what? Day after tomorrow is Saturday.
Moment.
Hmm?
Friday.
Day after tomorrow is, oh yeah, okay, day after tomorrow, Friday. Okay, day after tomorrow. On Friday.
Obligement.
Hmm? Hmm. Hmm? Okay, on the prayer of learned counsel, Mr. D. Bora, learned counsel, the matter stands adjourned and to be listed after a week. Okay. It is submitted that consent has been taken from the counsel appearing for the other side. 34. Huh? These are bail hearing. Huh? 35, 36? How can it be like different, separately taken up? You take it, I will take it up. I will take it up. I will pass it over for some time. Hmm? Only 34 and 36 is tagged. But 34 is also same matter, same. So you take instructions, we'll take it up. You take instructions, you take 2 instructions for this thing. 52. Yes, 52 is 52. Why are you mentioning? Why? Okay, let it be listed on the prayer of Mr. P. Bordelais, the learned counsel appearing for the accused. Let the matter be listed on Friday, that is on 24th. Interim order to be continued till the next day.
Item 57, Worship.
Hmm.
Cover for the Netflix on 29.
Why AB to be adjourned?
CDs.
CD not received. Okay. You are Mr. Mr. A.H. Ahmed is present for the accused applicant. CD not received. Let the matter be listed
29.
On,
Yes,
on 29th July. 54. Why? She did not come. Your name? Mr. A. Gayan is present for the accused applicant. CD not received. Let the matter be listed on 31st.
May it please your lordship, with the consent of the other party, I beg to mention item 21. Can it be listed after 2 weeks? Conducting counsel is unwell. We have submitted adjournment slip also.
21.
Yes, lordship.
You are appearing for?
On behalf of Ditul Das, sir.
Hmm?
For the petitioner, on behalf of Ditul Das, sir.
Okay, on the prayer of MS so-and-so appearing on behalf of Mr. Ditul Das, the learned conducting counsel, let the matter be listed. After 2 weeks,
Yes, lordship.
after 2 weeks, she submits that she has already taken consent of the counsel appearing for the other side.
And lordship, interim may be continued.
Interim orders of past earlier shall continue till the next date of listing.
Oblige.
58. 58. CD not received, let the matter be listed, let the matter be listed on 31st.
May I please your lordship, with the consent of other side, I beg to mention item number 18. Lordship, this matter may be adjourned for 3 weeks.
Uh, hmm. Okay, parties are duly represented. It is, as I mentioned, has been made for adjournment of the matter due to the fact that some out of the court talks for settlement of the issue is going on. Let the matter be listed in the third week of August.
Lordship, interim may be
On a date to be fixed by the registry, interim orders of past earlier shall continue to the next date of listing.
maybe. I don't know, 46 minutes ago, all for, and said.
CD not received, let the matter be listed on 31st July. 4th of August, 4th of August, interim order to continue till the next date of listing.
Oblige. Then 65, 42.
It is your lordship. Lordship, on the instruction of the client,
Okay, your name?
P. Majumdar.
Mr. P. Majumdar, the learned counsel, appearing for the accused applicant, submits that he has instructions to withdraw the instant case. Accordingly, the instant bail application is dismissed on withdrawal.
Thank you.
Item 1, question.
Seven also same.
Page number 8 is there. Already 53 days given the 60 days.
We will call for the CD in this case.
53 days, madam.
Huh?
Maybe
53 days. Okay, heard Mr. H. Ali, the learned counsel, appearing for the accused applicant, also B. Sharma, learned AP for the APP for the state. I'll call for the CD, let them, decision application you write, decision application under section. You take it from here. Then you call for the CD, let the matter be fixed on 53 days.
Right.
Sometime on 31st or 3rd of August. It will be over, no?
from Haju, madam.
From Hajar. Huh? Okay, 20, let the matter fixed on 28. Same order, the other matter also. You are,
Heavy, madam.
but it's a navy.
From
And
Haju.
then, huh? For the father. Okay, fine, you write this thing. We'll see the CD. You write the same thing only, but all the only difference is the AV. application under so and so maybe.
For a kidney application also, Kirtana was arrested on 1/7/2026, Lordship.
Hmm?
1/7/2026, Lordship. Here we have taken the plea for non-compliance of 30 notice issued under 35(3) also.
35?
35(3) of BNSS. That was not
Okay,
issued.
we'll see the CD then.
Lordship.
Heard MSF, SK Nargis, SK,
Nargis.
SK Nargis, the learned counsel appearing for the accused applicant, also Mr. B. Sharma, learned AP for the state. This is an application under so and so, call for the CD. Let the matter be fixed on 5th of August.
Obliged. Remove of the place.
Hmm?
Page number 80. Brief of the place. The affair case will not fail.
Okay, we'll call for the CD. Heard Mr. M. Hawk. M. Hawk, learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APP for the state. This is an application under so and so, call for the CD, let the matter be fixed on
14 August.
14 August. Why so late? Hmm?
10, madam, 10. 10 August.
Okay, 10th of August. 10th of August is also the late. 6th of August. Why you want so late date? Is there any reason?
Today's third one days. This third one.
That cannot be a criteria. That cannot be a criteria to list it after 2 months. Then you file in a date wherein you'll be in a you'll be nearer to your date. I mean mandatory period.
Request.
You can't do that. The investigation is going on. Anytime the CD can be, charge sheet can be filed. Yes. Okay, heard Mr. D. Bora, the learned AP, learned counsel again for the accused applicant, also heard Mr. B. Sharma, learned AP for the state. There is an application under so and so, call for the CD, let the matter be fixed on 7th of August.
5.
Hmm? Yes. Yes.
Find out the co-accused. I was not present in.
You were not there. Yeah, Asik Ali is not named.
My name was some the other arrested co-accused. They took me. Actually, my lord.
No, you have fled away from the place.
I was not present.
আৰু তেখেত লগত সকলৰ লগত পলাই যোৱা ব্যক্তিজনৰ নাম আছে Asik Ali. Not co-accused. You have, I mean, whatever. I mean, you have. Yes, tell me what is your case.
My case was mine. I was named by the co-accused.
Hmm.
I was not present, my lord.
Why you have been named? Then your co-accused could have named anybody under the art. Why your name has been taken? Why your name has been taken? There was any enmity. They wanted to plant you. They wanted to put you behind the bars because of some enmity. That's why they have taken your name. Huh? What may be?
Of the other co-accused later failed.
Hmm?
The co-accused, 4% were arrested.
Hmm. You granted bail. Where? Order?
Regular bail.
Hmm? Page 34.
From an Excel file, page number 26.
But you have other antecedents also. There are certain cases pending against you.
My past record is not so clear.
Hmm?
My past record is not good, my lord.
Not good. Then why should we grant you bail?
Because of that, my past record is, my name is included, man.
Hmm? No ground. You have been rejected recently only. There is no other ground.
Call for the case.
Why should I call for the case diary? Okay, let us call for the case diary. I'm not giving you any interim. Heard Mr. C. Chakraborty, the Learned Counsel appearing for the accused applicant. Also heard Mr. B. Sharma, Learned APB for the state. There is an application under so and so. Then you write call for the CD. Let the matter be fixed on 6th of July, 6th of August.
Then 6. May I please your lordship, my lord, this bail application has been prepared for the petitioner.
Hmm?
For the this clear is bail application.
Yes, where is your FIR?
FIR at page, my lord, 12, my lord, started from 12 to 13, my lord.
Mr. Ahmed, I mean, we'll have to call for the CD. We won't be able to give you any interim in this.
In the meantime, my lord, if your lordship,
Hmm?
in the meantime, my lord, if your lordship, please interim, sir.
Interim will be difficult,
Will
will be
kindly
difficult.
granted till next statement,
Hmm?
till receipt of the case, they remain. In fact, it is a accident.
You are running a sawmill, somebody
Yes,
got
yes, yes,
somebody got injured and died, you did not inform to the police. What is this? What is this conduct?
There is allegation, my lord,
The allegation, I mean, we'll go, I mean, at this stage, we'll go with the allegation only.
but in absence of the.
But why, have you informed to the police? Where is the document? You have not informed to the police.
Initially, he was.
Now, whatever it may be, there was some accident happened, somebody
Why does it
died. We should have informed the police, intimated the police about the incident.
Initially, he taken to the hospital, my lord.
He was
Petitioner
taken to the
him in the hospital, my lord, as soon as accident taken place, my lord. And unfortunately, he did not lose the Azahar, this in fact, my lord. On the same day, he died. But during treatment, my lord.
Okay, heard Mr. N. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. This is an application under so and so. An FIR was lodged on 15/5/2026 by one Kanindra Kalita, informant alleging that his father was working in the sawmill of the accused person. And during such walking on 15/5/2026 at about 5:30 p.m., he suddenly he met with an accident due to some fault of the machine and sustained injuries. It was alleged that thereafter he was taken to the hospital, and namely Swati Hospital. Therein, therein, therein he succumbed to the injuries. It was alleged that though the incident happened, the incident was not informed to the police by the accused applicant. Full stop. Full stop. Then you write Mr. N. Ahmed submits that the accused that the incident is purely of accidental in nature, and the victim was immediately taken to the hospital, wherein the victim succumbed to the injuries. However, the same incident was not informed without any intention. Not informed to the police without any intention. He submits that the accused applicant shall cooperate with the investigation in the event of any protection granted to him by this court. Taking into account the aforesaid, this court directs that in the event of arrest of the accused applicant shall be granted bail on furnishing of a bail bond of rupees 20,000 with a surety of like nature to the satisfaction of the arresting authority in connection with Rangia Police Station case number 119/2026, subject to the condition that the accused applicant shall appear before the investigating officer within a period of 7 days from passing of this order, and shall fully cooperate with the investigation by making himself available as and when called for by the investigating officer. Full stop. Next para. Interim pre as well, release on interim pre as well. Then you write, call for the CD, let the matter be fixed on 12th of August.
Must. Anyway,
It's resolution. This is a political bail application, my lord. FIR is at page number 13, my lord. Tax copy of the FIR, my lord. And the honorable court was pleased to grant interim bail to the co-accused, my lord. I have annexed the order, my lord. Co-accused was granted interim bail, my lord. I have annexed the order in page number 19.
Interim bail was granted.
Interim bail granted, my lord, fixing case diary for 24, my lord. Fixing for case diary on 24, my lord. I have annexed the order, my lord, 1920, lord 6.
Where is the order?
Page
Page?
19 and 20, lord 6. Annex the 3, lord 6.
Okay, right. Yeah, who are you? Are you also
I'm the
the
brother of the other accused, my lord.
brother of the accused?
Yes, my lord. My lord, been captured. Younger brother, my lord, Rohingya, my lord.
Your name, your name?
Rohingya, my lord, Borgohai, my lord.
Your name, no, no, your name, counsel's name.
H. Rahman, lord.
Huh?
H. Rahman, lord.
H. Rahman. Okay, heard Mr. H. Rahman, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APB for the state. Reason application under so and so, so and so. Then you write an FIR was lodged on 22/5/2026 at Nazira Police Station, alleging inter alia that on 21/5/2026 about 12:15 a.m. a scuffle took place between his nephew Abhishek Borua and the and the
Applicant's
you
brother.
were also there.
Applicant's brother, lord.
And the accused applicant. You were there, na?
Yes, sir.
Arendra Borgohain was there,
Yes, sir.
accused applicant. And during that time, the younger brother of you have assaulted.
Yes, alleged to be assaulted, my lord.
During that time, the accused applicant assaulted his nephew with sharp weapon. It was alleged that his nephew was injured and thereafter he was taken to Sibsagar Civil Hospital initially and thereafter to Assam Medical College Dibrugarh for better treatment. But you have assaulted, we cannot grant you any interim.
That and another case is fixed on 20.
Another case fixed, but that is fine. We'll fix it on that same date, but without any
On
interim.
the same day, sir.
On receipt of the FIR, police registered Nazira PS case number 25 stroke 2026. Call for it is submitted. Call for the CD and let the matter be fixed on 24/7/2026.
Obliged, sir.
TLS bail application, FIR is at page 16. Allegation is the theft of oil from the oil tanker and petitioner and driver and helper of the oil tanker.
Petitioner is?
Driver and helper of the oil tanker. Page 16, 1/6.
So we'll call for the CD in this case.
So the Lordship may kindly consider, my lord.
What?
The
You know that that the vehicle is engaged in theft, but still you were driving that vehicle.
My lord, no,
It-
they are not at, there is no theft, my lord, and they are not at, Lordship may, the allegation in the FIR is that, my lord, the police got the information,
Hmm.
and when they raided the house of one Bipin Rajkumar, my lord, they found the vehicle is standing standing there, my lord.
Where is the affair?
Page 16, 1/6, my lord.
Read the affair.
I'm reading from second paragraph onwards, my lord.
Hmm.
Accordingly, the information was entered by GD number so and so, dated so and so, and thereafter, I along with Sri so and so, and police staff immediately proceeded to the house of said Bipin Rajkumar and conducted a search operation. During the raid, one diesel oil tanker bearing registration number so and so with Oil India marking on its body was found standing at the premises. The aforesaid accused person was caught.
The aforesaid accused person was caught red-handed
Yes.
while stealing diesel from
Diesel.
the said tanker.
Yes, my lord, and transferring the same into
Own plastic drum.
drums. At the time of arrival of the police party, 2 drums were found fully filled, containing approximately 50 liters each, and
Mm.
one drum was found half filled, containing about 20 liters of diesel. On seeing the police party, the driver and his associate of the tanker fled away from the escort. However, the owner and owner so and so was arrested, my lord.
So,
My lord, Lordship may kindly see, my lord, the vehicle was taken into Jimma by the owner, my lord. And then, my lord, it was unloaded in the, my lord, IOCL campus.
Hmm?
Page 23, my lord, the report. There is no difference, my lord. There is no theft, my lord. Page 23, my lord.
then why this, this was, why he fled away?
Lord, they have not, I have stated in my paragraph 6, my lord. If Lordship may take, my lord, page 6, para 6 of my petition, my lord. I have stated, my lord, I have stated in my petition that on that day, my lord, there is some mechanical problem. So they have stopped the vehicle. They were present there. At that time, the police reached there and the vehicle was standing in front of the house of the Bipin Rajkumar, my lord. And
Bipin Rajkumar, I mean, there was some information that there was some stealing.
the Bipin Rajkumar is, my lord, he was arrested and my lord, some articles were also found from his house, my lord.
Hmm.
But with regard to theft, my lord, nothing is there, my lord, because the difference, there is no difference, my lord. It was unloaded in the, my lord, refinery. My lord, page 23, my lord.
But what about this 20 liters of diesel half fill containing, then
Well,
how,
the-
then
well, well,
if there is no difference, where is the report of not difference?
My lord, page 23, my lord.
Huh?
Page 23. The vehicle was taken into Jima, then it was sent to the refinery, my lord, for unloading of the oil, my lord. Page 23. The last two columns, my lord, difference in deep, difference in volume.
Hmm?
Last two columns, my lord, difference in deep, and the second is difference in volume. My lord, these are the oil tankers are now sealed, my lord, after filling, my lord. So there is no chance of any opening, my lord. And I have stated, my lord,
Oil tanker is owned by whom?
owned by one Hardeep Singh, my lord.
Hmm?
One Hardeep Singh, my lord.
Hmm.
He is the owner of the oil tanker.
So your case is that the oil tanker was going there, going somewhere, going to the refinery or whatever.
No, my lord, they have filled that, the oil was filled from the refinery.
Oh,
And then it was.
then it was supposed to go to your destination,
Yeah,
some
but
destination.
in
Then some mechanical defect.
some problem.
Mechanical defect incidentally happened before this, the house of this person, who is in the habit of stealing oil or something like that, right?
My lord,
That there's a coincidence. So coincidentally, it stopped there. Then oil was, I mean, taken out from there. Probably it was about to be taken out. Then police came. Then you people fled. Now, so there is no difference in the dip. Correct. That is the story.
my story is this, at that time the vehicle.
So your, I mean, that's what I'm saying. I mean, the vehicle, so coincidentally it happened that your vehicle had some mechanical defect just in front of the house of a person who is known to be a thief of oil. And police got the information. When police went to the spot, then I mean, you being a driver, you fled away.
No, my lord, I have stated that these persons are present. The
Hmm.
police have not arrested them at that.
Hmm.
I have stated in paragraph 6, my lord.
But how this difference is not there, I could not understand. Because the allegation is that there are two drums found fully filled, containing approximately 50 liters each. And one drum was found half filled, containing 20 liters of diesel oil.
My lord, it is not possible nowadays to, my lord, take out the oil from the tanker, my lord, because after, my lord, loading that oil, now it is sealed, my lord. The seals are kept.
So I mean, these people are high tech people. You are not aware probably. High tech, they can do anything. Seal is nothing. Seal is nothing. Breaking up a seal of a tanker, you are saying. They can do anything. They have high tech machineries imported from Russia, imported from all these I mean countries. And they do it.
Thing is that, my lord, there is no difference, my lord. So there is no question of any theft, my lord, from that vehicle.
Okay, heard Mr. A.K. Gupta, the learned counsel appearing for the accused applicants. Also heard Mr. B. Sharma, the learned AP for the, I'm not giving you any interim. So and so, then an application under so and so, all for the CD, let the matter be fixed on. It is coming from where? Dibrugarh,
Big boy, my lord.
Digboy, Tinsukia. So we'll fix it on 7th July, 7th of August.
Can it be earlier to that, my lord?
Earlier to that, okay, that privilege I can give you because you are a high tech person. 3rd of July, 3rd of August.
Perfect.
Please, Lordship. My lords, 3 hours bail is in your lordship. FIR is at page 9, Your Lordship. Allegation in a nutshell, Your Lordship, that on the day of incident, Your Lordship, on 29/6/2026, Your Lordship. So on the pretext of some reason or the other, Your Lordship, to visit the informant somewhere, Your Lordship, taken to the house of vacation number 1, Your Lordship, in a four-wheeler vehicle, Your Lordship. And from thereafter, from there, Your Lordship, taken to, Your Lordship.
Okay, we'll call for CD. Heard Mr. Heard Mr. A. Diwan.
Lordship, there is a case on merit, Your Lordship.
There is no case on merit. There is no case on merit.
18 may kindly be looked into. The accused number 1 is the husband, Your Lordship.
Then he
So
took,
if
and he took
husband
his
and
friends.
wife,
He
husband-
took his friends along
No,
with
no,
him.
No, Lordship.
What is the allegation?
Allegation is, Lordship, married, Your Lordship.
Hmm.
Married, Your Lordship,
Hmm.
with due respect, to on 29/6/2026
Hmm.
at 4 p.m.
Hmm.
The accused person, on the pretext of visiting me somewhere by enticing me in various ways, took me away
Hmm.
from the from house in a four-wheeler vehicle, and
Hmm.
thereafter they took me to the house of the accused number 1.
Hmm.
Subsequently, the accused person transported me by
Hmm.
boat to Sunville
Hmm.
Shore. The accused person thereafter.
No, I mean, no, there is no, I mean, you may be a husband, but your friends also were there, and like she was, on the pretext of going somewhere, you have taken to a chore, then like this offense was committed, and why are you saying that like you are husband, you are husband, you are husband?
But she has filed.
He may be a husband,
She has
huh?
filed an affidavit, Your Lordship.
He may
Page
be a
20,
husband.
Your Lordship.
Where is the affidavit?
Page 20, second para, Your Lordship.
Hmm.
Today, the victim woman is present before this court in person and submitted an affidavit stating therein that the accused Rabiul Alam is.
Where is their affidavit?
Lordship.
Where is their affidavit?
Affidavit is not there. It is reflected in the
You
order.
give me the, you put the, you bring the affidavit.
Reflected in the order.
Then don't, no, you bring the affidavit.
The reason being that, Your Lordship, we are not totally present in the place of occurrence, Your Lordship. There is some personal family feud, Your Lordship. So they picked up quarrel.
Who is Ribul Alam?
Is the husband, Your Lordship.
So Ribul Alam has gone.
Yes, Your Lordship.
Yes, then who is this Ikramul?
Rest of the accused person, they have been implicated, Your Lordship.
Now who Ikramul Hussain is whom?
Ikramul Hussain is one of his acquaintance, Your Lordship, of the Rubul Hussain.
So accusation against them?
Allegation is, Your Lordship, this.
What are you arguing? So allegations are against them, isn't it? For rape, for rape.
Specific allegation against all, Your Lordship.
Correct. So you are accused of rape, and without going into the series, should I give you this thing?
Lordship.
Then why you have wasted the time of the court? I was about to dictate the order. You said that the husband has gone, husband accuses the husband, whatever.
Only the.
I mean, what kind of submission you make?
Sorry.
Hmm?
Sorry, Your Lord.
Heard Mr. A. D1, the learned counsel opinion for the accused applicant, also B. Sharma, learned AP for the state. Is an application under so and so, call for the CD, let the matter be fixed on 7th of August.
86.
Lordship is a pre-earnest bail application. Lordship, FIR is at page 13. Effective portion will be at from page 17. Lordship, there is a. If I may read that.
Page
Page
17.
17. Here, Lordship, it says that information was received that some people will gather in a particular place in Nagaon district regarding, Lordship, some offenses,
It's-
cyber offense.
Cyber offenses and betting and all.
Not betting, Lordship.
Not betting.
Forgery, cheating, and cyber offenses.
Ah.
Lordship, at that point of time, Lordship, the petitioner was also present in the restaurant. But however, Lordship, if we go down in the Ejahar,
Hmm.
we'll see that the second last paragraph, during further inquiry, it was found that Ashraful Islam, son of so-and-so, is an active member of the said cyber fraud syndicate. Pertinent to mention that on 2/5/26, one Bishal Kumar Bora had submitted a petition against the said Ashraful Islam. Accordingly, Nagaon PS case number 28 was entered and the inquiry conducted thereafter revealed incriminating materials against him.
Hmm.
But Lordship, the petitioner, against the petitioner, there is not a single Lordship mention of any offense committed by him, any kind of complaint or FIR lodged against him. Only that the petitioner, who is a pharmacist, he happened to be present in the restaurant that day. He was having his lunch. Some other people were, Lordship, caught, and he was also present in the restaurant, Lordship.
Okay, we'll call for the CD.
Lordship,
Okay,
only
we'll
the
call,
Lordship,
no.
Is required, Lordship, he is a heart patient. He has two minor children, Lordship. In fact, Lordship, police barged into their home. They were not present at that time.
It will be difficult, madam,
Lordship, the
interim.
Lordship, the police.
We'll give you a
case
short date,
included-
we'll give you a
Yes,
short date, okay?
In
We'll-
fact, Lordship, even the children's laptops, their study materials, everything has been seized, Lordship.
we'll just give you a short date, but we won't be able to give you protection in this
Because
case. Eh?
He's a heart patient, he's having great difficulty, Lordship.
A short date we'll give, okay, a short date. It is Nagaon only,
Nagaon.
not, it will not take much time. Heard Mr. MSP Burwa, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APE for the state. There is an application under so and so, so and so. Then you can call for the CD, let the matter fixed on the earliest when 3rd of July, 3rd of August.
Can it be fixed, Lordship, a little earlier, Lordship, on 31st of July?
31st CD may not be coming. So it's better you keep it on 3rd only.
Lordship, the case of NDPS and the
Hmm? Who is there? Customs Department. We'll pass it over for time being.
Tracking report is there on last of the record, Lordship. It shows as delivered. Tracking.
Hmm? But AD hasn't come back. So we'll appoint somebody then. Heard Mr. D. Medhi, learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. Who has filed this tracking report?
Lordship.
This is tracking is done by whom? Registry. As per the tracking report, which has been put up, which has been put on record by flag A, it is seen that notice seems to have been delivered to respondent number 2 on 16/5/2026. However, when the matter was called for, none appeared for the respondent number 2. Scanned copy of TCR has already been received. Taking into view the aforesaid, this court appoints. Appoints Srimati Dipti Pathak as amicus curiae to represent respondent number 2 and assist this court. Let the matter be listed on 7th July,
7 August.
sorry, 7th August. A copy of the bail application to be served on the amicus curiae during the course of the day.
Deeply obliged.
24.
Twenty-two C, 22C of the NDPS Act. Your
Hmm.
lordship has directed me to file the witnesses that has been examined. I have been informed that 2 witnesses has already been examined, but we could not get the certificate copy till date. So I pray for 2 days more time to get the certificate copy and to file the same.
Okay. On the prayer of the learned counsel appearing before the accused applicant, let the matter be listed on 4th of July.
So sorry.
Sorry, August, 4th of August. 4th of August. In the meantime, you'll file an additional affidavit.
Yes, lordship.
In the meantime, the learned counsel appearing for the accused applicant shall file an additional affidavit bringing on record the statements of the witnesses made before the learned trial court.
25.
May I please, Your Lordship? Not a regular bail in a, my lord, surseated case.
Hmm?
Regular bail in a surseated case, my lord,
Hmm.
offense under section 4 of the POCSO Act, my lord, and 65 rape, my lord, ENS.
65 days.
In this case, my lord, already charge has been framed. And the, my lord, 3 witnesses, that is the victim and the, my lord, the parents, they have already been,
Victim and
victim and the parents, my lord, of the victim. These 3 witnesses have already been examined. And my lord,
yes. So, I mean, trial is going on.
Trial is going
in
on.
right direction. So why should this court should
Only-
interfere?
Only thing is that, my lord,
If you can spoke so.
regarding, my lord, the rape and the, my lord, the sexual, my lord, the penetrative sexual assault.
Hmm.
My lord, the victim declined to go for the medical evidence.
No, correct, but the trial is going on in the right direction.
I am only on that, my lord, because, my lord, to prove, my lord, that it is a, my lord, rape or a, my lord, penetrative sexual assault, my lord. For that, my lord, there ought to have been, my lord, the medical examination. But that, my
That trial will decide, trial court will decide, trial is going on. I mean, you just wait for some time. I mean, at this stage, why should this court interfere when the trial is going on? And Supreme Court has categorically stated Supreme Court has categorically observed that when the trial is going on in the right speed and there is no such delay, then the interference from the courts are not required.
I am on, my lord, only on that, my lord.
That point is, I mean, because the trial is going on, trial will decide this.
And my lord, almost, my lord, more than 10 months I am behind the bar, my lord. And, my lord, there is contradiction in the evidence, my lord. I have annexed the, my lord, the deposition of the, my lord, the victim guard also, my lord. There has been contradictions in our, my lord, evidence and her statement before the, my lord, police.
For sure. The case as well, Supreme Court X versus state of if a
The thing is that, my lord, the victim has stated, my lord, they had love affairs. But only problem is that, my lord, her age.
So you are behind the bars for last 10 months.
Yes.
This trial started when? I mean, when the charge was
28
framed?
and 25.
Hmm?
28/10/2025.
28/10/25.
10/2025, about more than 9 months,
25. And how many witnesses are there?
my lord.
How many witnesses are there?
Total, my lord, witness about, my lord, 10,
10.
10 witnesses.
10 PWs, out of that three,
We
how
have
many?
already been examined.
Three already been examined. Three examined.
And they are the most vital witnesses, my lord, victim and their parents.
Yes, Mr. Sharma? Oh, sure. Why CD is required? So please submit on merit, Mr. Bishop. Don't submit on CD is not available. What is to be done with the CD? Hmm. 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 Hmm.
On 26, my lord, the time of the assessment, the service payment.
Hmm.
Directly there to the accused. And regarding my the delay part, follow the that is the trial is going on. That's my lord.
Mr. Chaudhary, trial has started. I mean, three witnesses have been examined, so we do not want to interfere at this stage. Trial is going on a good speed, reasonable speed. Charge was framed on 28/10/2025, and till date, three are already examined. And serious allegations are there. Heard Mr. B.M. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Boisha, the learned APP for the state, as well as Mr. D. Mehdi, the learned counsel appearing for the respondent number 2. This is an application under section 483 of BNSS. You write down this, then you write. An FIR was lodged on 27/10/2025 by one Sadhu Das, the informant, alleging inter alia that his minor daughter of 15 years of age had been missing since the evening of 26/10/2025. It was alleged that later a person named Raju Kormakar informed him over the phone that he married the minor daughter of the informant and has kept her at a rented house in Gormur. It was alleged that despite already being married, despite already being a married man with a wife and daughter, the accused person lured away his daughter and married her and established physical relations with her. Next, in terms of in view of the aforesaid FIR, police registered Jorhat PS case number 568 of 2025 under section 137 under the aforementioned sections. The charge in the instant case has been framed on 28/10/2025, and out of 10 PWs, 3 PWs including the victim and the informant have already been examined. The learned counsel appearing for the accused applicant submits that the accused applicant is behind the bars for last 10 months, for about last 10 months, and since the primary witnesses, that is the victim girl and the informant, have already been examined, the accused applicant may be granted bail at this stage. TCR in the instant case has been produced and prayer for bail of the accused applicant has been opposed by the learned APP appearing for the state. This court has produced the TCR and taking into account of the fact that the case relates to a serious offense of rape and trial has already commenced and 3 witnesses have already been examined, is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant bail application is disposed of. Bail application is rejected and disposed of.
Maybe at this stage, my lord.
At this stage, we have given.
I'm obliged.
At this stage.
26.
May it please your lordship. There is an application under 483 PNS. Here, your lordship, the petitioners were arrested on 22/1/2026.
Hmm?
Now,
22/1.
22/1/2026.
Hmm.
There is a charge, your lordship.
22/1/2026. Okay.
Charge under section 21C, 25 and 29 NDPC.
Hmm.
Lordship will kindly go to the FIR first. That is at page 18, 18.
This is NDPS.
18,
Your item is item number
26.
26.
18, page 1. Lordship,
In the office note, it is written to return a scan copy of TCR sent to special court POCSO. Then what is this? Then I'll have to see. This is NDPS case. Yeah, this is in POCSO. Scan copy of NDPS. Can I give a No, इसको भूल के रखो पूरी. I have to say NDPS case now. NDPS case number 32.
as per my learned friend, the NDPS case scan copy.
Yeah, and NDPS cases come by on the official note, it has been written, it was sent to requisition of the POCSO case. That's what got confused.
There may be some. Anyway, your lordship will kindly take up page
Hmm.
18, DFI. Yes, your lordship, TCP, it was
Page 18.
page 1A.
Hmm. Yes.
Your lordship will see that this is dated 22/1/2026.
Hmm.
I'm coming to the date because of there's a specific ground taken with regard to non-production within 24 hours by the police. So that is since that the first paragraph, your lordship, I have the honor to inform you that today on so and so morning I was detained for regular NACA checking at so and so along with my other colleagues, so and so, so and so, so and so. APBN so and so. At around 9:30 AM, your lordship, time is part. While checking so and so motorcycle, was intercepted, which was coming from Rangpur side. The motorcycle rider was signaled to stop for checking, but the rider ignored and tried to escape from the Naka checkpoint. The police team has changed motorcycle riders and used a little bit of force to apprehend the two motorcycle riders. The apprehended motorcycle riders were questioned at the PO, where they were appeared to be nervous. Both the rider and pillion rider has been identified as one, Uttam Kumar. Number one is the petitioner here, your lordship, and so and so, and number two is so and so. And as suspicion arose, the apprehended accused persons might be carrying a narcotic substance, immediately inform the matter to so and so and other higher officials of Karbi Anglong, say so and so. A few moments later, Porsi so and so arrived at the PO who brought the NDPS kit containing narcotic test, electronic measuring machine, enveloped seal with box so and so, so and so. On his arrival, so and so has obtained the authorization letter from GO and also gathered two independent witnesses to witness the charge and seizure proceeding. Now, your lordship will kindly see. I'm not reading this witnesses and all. Next page, the first paragraph. This is another point which I'm going to take. At the next page, 19, the first paragraph. At first, the independent witnesses have charged, checked the body of myself, and after that, I have charged and aforesaid accused persons. While checking the body of accused person, Uttam Kumar Chauhan, the present petitioner, a total of 5 number of soap boxes, different color, have been recovered, which was kept concealed inside the back side jeep pocket jacket of the accused person. Here, I will wait for a moment, your lordship, to point out one thing, your lordship. Only 5 soap boxes were recovered from this petition. Number one. Now, this petitioner, 5 boxes, later on I'll come to that. If that is taken into consideration as a single unit, then your lordship, this comes to in between quantity, not a commercial quantity. The other part is with regard to the second part, another 25 boxes were recovered from the second person. And that taken together, they mixed it and have taken it together at that point of time. And then they weigh it and got it about 374 grams of heroin. Now, these are two parts. One is with regard to the body check of the charge of the petitioner and body charge of the other co-accused. In the body charge of the petitioner, it was found to be less than commercial quantity because your lordship will see 5 boxes. I'll come to the quantity part that is also there. From where your lordship, if it is taken to be maximum, then also it will come to less than commercial quantity. And the accused persons were then taken into custody in the last part of the said paragraph. So,
But both of you were traveling in the same bike. So you are conscious that like what he was carrying also. So that will be whether conscious position or not.
Is there or not with regard to the other part. That will come. Now, your lordship, second part comes. He was detained at 9:30 AM. Now, your lordship will kindly turn to page 21. Page 21 is the order passed by the learned magistrate first class in the forwarding. Just for a moment, I want to bring to your lordship that. Page 21, lordship has seen the order. That is on 23/1/2026.
Yes.
So this is the next. Now, your lordship will see.
He was arrested where?
22/1 at 9:30.
He was arrested near. Where was he arrested?
He was detained.
Detained where?
The detained
Place?
that was given in the FIR.
Intercepted coming from
9:30 AM.
where?
Well, this is
Naka checking,
Lang
one heroes were
Road.
coming from so and so side. But where is this place? Place is morning I detained detailed the Naka checking.
Hmm.
I'm along with my
Checking
brother.
at Lang Buku Road
become
along with
Sri-
my other colleagues.
Sri Lanka
so and
Manja.
so Of Salon
Uh,
M Manja PS.
So Manja,
Manja.
Siloni Manja PS. Siloni Manja PS.
Manja.
So Manja PS, and where is this Chief Judicial Magistrate First Class?
Judicial Magistrate First Class is.
In
uh,
Karbi Anglong, that means
this
in
is-
Difu.
Yes.
So what is
This
the
is in
distance?
Karbi Anglong.
What is the distance of
So
Difu?
between
Difu?
Manja and Karbi Anglong.
Hmm. So that distance has to be, time for the covering the distance has to be excluded.
That exact how many kilometers, I don't know, but check for it, yes. And your
So when he was produced?
he was
at-
produced on the next day.
Next day when, at what time?
That is where I am coming
Hmm.
in. See, what has happened? This is why I'm just trying to point out, there are
Hmm.
some difficulties here.
Hmm.
Because the exact timing has not been noted in the forwarding report. I have gone through that.
Hmm.
So I'm just pointing out two things, page 21, that is the reason I've taken your lordship.
No, correct. Now,
There are two.
now what is your ground? Your ground is that, I mean, he was produced beyond 24 hours, right?
Yes.
But
Why I have come to that, I'll come to that.
Hmm.
Your lordship will kindly see the page 21.
Hmm.
There are two.
Prepare 2 years.
Here, your lordship, seen the forwarding report,
Hmm.
arrest memo, inspection memo, notices of information under 47
Hmm.
and 48, and medical examination reports
Hmm.
of the accused persons. So here I wait for a moment. What I would like to point out is that this was after forwarding them, before forwarding, there was a medical done. So after doing the medical, he was forwarded.
Yes, that is the process.
Yes, that is the normal process. So medical, what was done, I could not annex that. I've got a certified copy of that.
Hmm.
It is
Some
done
injuries are there.
on 23/1/2026 at
Hmm.
12:13 PM.
Hmm. So you were
that is
saying-
beyond 20.
So you are saying that like before producing this person, medical was not done. Medical was not done.
Not done?
So whether that is a statutory provision
No,
or whether
medical
in.
was done.
Hmm?
Medical was done.
Hmm.
Then he was forwarded
Hmm.
because it is specifically indicated in the order
Hmm.
that after getting the medical reports, forwarding report,
Correct.
report passed the order.
Hmm.
So medical was done at 12:13 PM. That
Twelve-
means beyond the 24-hour period.
12:13 PM.
Yes.
PM. Hmm.
Now, your lordship, the distance from that part to Manja,
Hmm.
from Manja police station to Difu CZM Port Karbi Anglong
Hmm.
is 16.9 kilometers. Let us assume 17 kilometers. 17 kilometers at the most half an hour. At the most half an hour. Even if it is 1 hour. Cancel it, your lordship. Then also 12:13 goes beyond that period. And 12:13 is the medical report. After medical, reports have been issued, he was taken to the to the magistrate. There was again time. And one more thing I wanted to point out, when I said, because there were two things done, he was detained at 9:30. Immediately thereafter, within moments of time, the officer came.
What is the time in the arrest memo?
Arrest memo time is about 7:10 arrest.
Hmm?
7:10.
7:10 PM. PM.
But detention, your lordship, from 9:30, because they here already stated in the FIR itself that these people are apprehended. Both of them have been apprehended.
Because something was found, but they have not arrested you.
Arrested, but does it require?
But they have arrested you only through the arrest memo.
One more thing.
And you have accepted the arrest memo. You have not objected to the timing in the arrest memo.
I don't know that. I cannot say whether this has been accepted or not accepted, but because
Arrest memo was issued to
made
you.
and served.
You are not, you are not dispute, I mean, you have not disputed the time
But
of arrest memo.
whether when it is not produced under 24, does it make whether we will bring in the 47 and 48 and take everything together? Since you have not done this is okay. You may put him, arrest him anytime, produce him after 48 hours, 1 year, doesn't matter. That is what I'm trying to point out. These are all separate to each other. You have not done this, you have done this. You have done this, you have not done.
No, we are not worried about that. 47, 48, complied, non-complied, you are not taking the
I'm
ground.
not even arguing.
You are not arguing also.
I have
So
not
that
gone
we are,
through that.
we are
I have
not,
also not gone.
we are
through
not
whether
bothered.
they have been
You're only,
confirmed or not.
your,
Not 24 hours.
see, your
Not-
argument is 24 hours.
Now 24 hours, whether that has been complied or not.
Mm.
This is simple fact, I am just pointing it out. I am not going into a long, your lordship, argument on. a
Yes, what
different
is
fact
there
and
in the
fact.
CD?
One more thing, your lordship. Lordship has
Hmm.
pointed out, because your lordship's order have also annexed one order that your lordship has said. Detention and arrest, your lordship has, I have annexed that order.
Hmm.
That is why I have annexed that order, because this question might come up,
Hmm.
and your lordship has found out. And also on the basis of the judgment of the Honorable Supreme Court in Subhash Sharma, it has been specifically stated, detention and arrest. So these are two different things. After detention has to be counted. So I have annexed the page 42. I'm not arguing those things, because I think your lordship knows from the judgment itself. Therefore, but this point specifically, if it is 12:13 PM on the next day, what happened within 24 hours? Then my learned friends have to explain that. If your lordship satisfied, he is satisfied. What case I have?
See, law is clear. It is settled. Huh? Only exception is that, like, if you can prove that there are some more time consumed, that in traveling, transportation, some issues happen like that, then that time can be excluded. Correct. Otherwise, 24 hours, 4 hours is mandatory, and that is coming from the constitution, not from any other statute. So 22(2) non-compliance, he gets right to be released on bail immediately, because the arrest becomes illegal. So now you'll have to show me that what is there in the thing. His only argument is that. Hmm.
Is at around 9:30 AM while on conducting Naka sitting, one hero X plus motorcycle, and that was my Naka sitting point is at 9:30 AM. Now I'm MBPS matter, madam. And the other part, madam, I was madam to read madam entire part. Madam, to apprehend motorcycle riders were questioned at the place of occurrence where they were appeared to be Nakas, with the riders, physical riders, has been identified. Now, till that point of time, my lord, only my lord, one Nakasaki my lord, one my lord bike rider and the physical rider, they were my lord arrested by the police and asked the patients make it in. And at that point of time, they feel like later part. As suspicion arose, my I'm saying about after 9:31.
Mm.
As suspicion arose that the apprehended accused person might be.
So yourself you are saying apprehended. Apprehended means what?
But here, that point of activity, the next line is very clearly stated. As suspicion arose that the apprehended accused persons might be carrying narcotic substance, immediately inform the matter to OC Manda PS and other higher officials of Kardiango, DA Info 3, Deputy SP, so. Few moment later, OC Manda, so arrived at the place of occurrence, who has brought the MBPS box and so. After that, only the process started, independence witness were taken, body search and those started. So, in this case, when the OC was called, the deputy SP was called, though the interception was made at the point of time the Nakasa things at 9:38 on 22nd, it will take time. That that part is always there. And after taking the toolkit and doing everything, this process will take a time.
How much time it will take? It will take 2 hours, 3 hours.
It use the the arrest minimum. And that part. There is where it is stated as 20 to 1. But time of arrest is also mentioned. That is 7:30 PM.
No, correct. 7:30 PM. You can put any time. So police can put any time that I have. They think that they have all the liberties to put any time in the arrest memo. So yesterday also, Mr. Boysa, we have passed an order in similar facts and circumstances. And 20 delay in 24 hours. And there also arrest memo was issued later on when the persons were apprehended pretty early, because from a clear reading from the FIR, it transpires that they have been apprehended. They have been, so now this Niranjan Shah case and which has been referred to, this Niranjan Shah case, and Director of Enforcement, the Subhash Sharma case. Subhash Sharma case, it has been, all these cases have been, have clarified that you cannot, play with the words, arrest, custody, apprehension. Once you have taken them under your control, that means you have arrested them. Correct. So now timing has to be counted from that time. The Subhash Sharma basically said it is a case of airport. In the airport, somebody was taken under their control. Then he was sworn arrested in the night. Then in that case, Supreme Court has counted the time from the time when the person was taken under their control. That is clarified.
And even if your lordship, the seizure, I have annexed the seizure list. From the seizure list, the time is given.
Huh?
In the seizure list also, the time is given.
Time is given. What time?
That is, I think, similar, around 7, 8, 9, 10:30 or something. Just a minute. 11.
So 11
11.
o'clock seizure.
That is at page 35. So they have completed the seizure and everything by 11:46. This is 11:46 a.m. So very specific time. Page 35. This is the typed copy. And,
Where is the time written?
at the top, date and time of seizure. Page 46.
11:46.
46. Very specific time. Not 45. So this is everything already they have taken. everything.
11:46. Yes, 46. Then
And they have.
then
done the
you were
next
saying you submitted that medical was done at
medical.
12:15
actually, I
a.m.
got a that your lordship will get it in the records. I have got the
12:15.
copy only. I could not annex that. I have got a certified copy of it. It is shown to be 12:13 p.m. That is medical. Forwarding is after medical. I have a copy of that. I can forward this certified copy. But it is already, I think, it is there in
It is there in the medical report?
that has been, I think, like.
Okay, okay.
You can take my copy and then verify.
No, it's there.
So that form, it is shown as 23/1/26, 12:13 p.m. Now, date, time and date of examination. So this is the time of examination. After examination, reports were prepared. They went to the police. They went to the your lordship magistrate, then submitted it. It could not be beyond, I think, another 1, 2, 3 hours. If we take that view. But forwarding, your lordship, interestingly, time has not been given. So that is why I specifically asked for the certified copy of this medical report. And in the forwarding order, your lordship, by the magistrate, it has specifically, that is why I pointed out that these reports were before the court. And in fact, the court did not give any, I think, did not even remand. They were sent to judicial custody directly. 5 days remand was sought for, not given, because they have been injured.
No, but this ground of 24 hours, how will you meet this? You can't help it. You don't have any other than little bit of more training to the police officers. This court is time and again saying that that conviction rate in Assam is very, very poor in comparison to the national conviction rate. It's only 7% or 8%, whereas in places like Delhi, Haryana, the conviction rate is around 70%, more than 70%. Here it's only 7 and 8%, and this is only because of this. Only because of this. So pathetic, the investigation and the,
There
what do I
has to be
say?
some way out.
See, these are very, I mean, basic statutory provisions, and they do not follow this.
See, Lordship, what happens from these are the constitutional provisions. They should be knowing from the beginning what can be done. There were, I think, in one or two of my cases earlier, regarding 47, even the court has given directions to the commissioner of police or the superintendent of police in those certain cases. That was also nothing done. Later on, I think they must have complied with 47. Now 48 is also complied. Now this comes. One more after another they are doing. Something or the other comes out.
Okay, heard Mr. Y.S. Mannan, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Bashar, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with NDPS case number 32/2026 under section 61 in bracket 2 of BNS, read with section 21 in bracket C, stroke 25/29 of NDPS Act corresponding to Manja Police Station case number 02/2026, 26 full stop. The prosecution case in brief is that the informant Abdul Rafiq Sigdar lodged an FIR on 22/1/2026, stating that he was while during a regular Naka checking, while doing a regular Naka checking at Longvoku Road, along with his colleagues at around 9:30 a.m., one Hero X Pulse motorcycle bearing registration number AS09M1354 was intercepted, which was coming from Longboku Koilazan side. It was alleged that motorcycle rider was signaled to stop for checking, but the same was ignored and they tried to escape from the Naka checkpoint. It was alleged that police team chased the motorcycle riders and apprehended the riders. The apprehended motorcycle riders were questioned at the place of occurrence, and they have been identified as Uttam Kumar Chauhan and Suman Dahal. It was alleged that due to suspicion that the accused, that the persons might be carrying narcotic substance, the same was informed to the OC Manja PS and other higher officials of Karbi Anglong. Thereafter, OC Manja PS along with Deputy Superintendent of Police arrived at the place of occurrence, and on searching the body of the accused Sri Suman Dahal, a total 25 numbers of soap boxes have been recovered, and why have not you mentioned about the recovery from your possession? in your petition,
Yes.
in the FIR portion that you have summarized, you have not mentioned about the recovery from you. Is it intentional? Or is it a drafting skill
No, I
that,
don't know
that,
about
that, that, that
I
you are
think
filing a bail application and you are not mentioning about the recovery from you, but you are mentioning about the recovery from your co-passenger?
I think it has been missed up. Should have been, because
Maybe it's a drafting skill, Mr. Mannan.
no, I don't think so, because I have not drafted bail applications. I have never.
Somebody must have thought it's a
Yes.
drafting skill, not to mention there.
But it has been specified later on.
Anyways,
The total amount has been given.
anyways,
And annexed
Jahal,
also. It has been
and
annexed. Yes, it's लिखा ना, it's from Kumar को. 25 boxes, 1 from Kumar 5.
and a total of 5 numbers of soap boxes suspected to be heroin inside
No,
were,
para 4 he has stated, your lordship.
were recovered from Sri Uttam Kumar Chauhan. It was alleged that inside the soap boxes, some brown powder were recovered. Inside the soap boxes, some brown color of powder was recovered, which was suspected to be illegal narcotic substance, that is heroin. It was alleged that test was conducted on the recovered powder and it was found to be heroin. It was alleged that total amount of powder recovered, suspected heroin recovered, was 374 grams in total. In view of the aforesaid, in view of the aforesaid FIR, Manja Police Station case number 2/2026 under the aforementioned sections was registered. The registered. The accused applicant was arrested on 22/1/2026 and forwarded to the court of learned judicial magistrate first class Karbi Anglong. And since then, the accused applicant is behind the bars. Mr. Y.S. Mannan, the learned counsel appearing for the accused applicant, primarily argued that while arresting the accused applicant in the instant case, the mandates of Article 22(2) have not been complied with by the arresting authority. He submits that though the accused applicant was arrested at 9:30 a.m. on 22/1/2026, the accused applicant was produced before the learned court of judicial magistrate first class, Karbi Anglong, on 23/1/2026, beyond 24 hours. He submits that in the forwarding report, the mention has been made about compliance in terms of issuance of arrest memos, inspection memos, notices under section 47 and 48 of BNSS as well as medical examination. Full stop. He submits that as per the medical report, the time of medical examination has been shown at, what is the time? 12:30?
13, 1.
12:30?
This is the.
No, this is, he is looking into it. Anyways, 12:30. 12:30 PM on 20,
Not 30,
three.
1.
12:13 PM on 23/1/2026. He submits he submits that the aforesaid fact indicates that the accused applicant must have been produced before before the learned JMFC post 12:13 PM. He submits that if that is so, then the accused applicant must have been produced beyond 24 hours, which is in violation of Article 22(2) of the Constitution of India, and thereby vitiating the whole procedure, the whole process of arrest of the accused applicant. He submits that on that ground only, on that ground only, which is clearly against the mandates of the mandates of the provision of the Constitution, gives the accused applicant an unfettered right to be released on bail. I'll just come back in 5 minutes, Mr. Nandan. Oops.
I know, we can. file nalai. Click it. Kata eh. এখন file nalai. Thank you.
So, Mr. Boyso, this is special judge Kamrup Metro or special judge Assam for anti-corruption cases? Special judge Assam. That is for the whole state, right? Jurisdiction for the whole state. Yes. What is the last line? Okay, okay. Mr. K. Boyso, the learned, Mr. K. Boyso, the learned, one is K. Das. K. Boyso, the learned APP, opposes the bail application stating that huge quantity of narcotics, that is heroin, have been recovered from the accused applicant and the co-accused and co-accused. Therefore, the prayer of bail should be rejected. He further submits that as per the arrest memo, the arrest was done only at 7:15. 7:10 PM on 22/1/2026. Therefore, the production of the accused applicant before the learned court of JFMC Karbi Anglong is within 24 hours time as prescribed under Article 22(2) of the of the Constitution of India. Full stop. The scanned copies of the TCR in the instant case has been received and the same is perused. On perusal of the on perusal of the case, on perusal of the records, it is seen that the accused applicant was apprehended and taken under control of the police at about 9:30 a.m. 9:30 a.m. And thereafter, then thereafter, and thereafter, mm, and thereafter, the process of testing of testing of the seized contraband was carried out, and the accused applicant was produced before the learned JFMC court. It is though there is no mention of any time as to at what time exactly the accused applicant was produced before the JFMC, the learned JFMC court, Karbi Anglong, from the order dated 23/1/2026, it transpires that before production of the accused applicant before the court of learned JFMC Karbi Anglong, medical test was conducted. From perusal of the medical report, it is clear that the medical test was conducted at 12:13 p.m. on 23/1/2026. This indicates that after the medical report only, the accused applicant was produced before the learned court of JFMC Karbi Anglong. This clearly, therefore, it is discernible that the accused applicant must have been produced before the learned learned court of JFMC Karbi Anglong after 12:13 p.m. on 23/1/2026, which is clearly beyond the prescribed time of 24 hours. Full stop. Taking into account the ratio laid down by the Honorable Supreme Court in the cases of Niranjan Singh and another versus Prabhakar Rajaram Kharote and others reported in 1982 SCC 559, as well as in the case of Directorate of Enforcement versus Subhash Sharma reported in 2025 SCC online SC 240. This court is of the considered opinion that the accused that by producing the accused applicant beyond 24 hours before the learned court of JFMC Karbi Anglong, there is a commission of there is a violation of Article 22(2) of the Constitution, Article 22(2) of the Constitution of India. It is also from the aforesaid facts, it is discernible that there is a violation of mandate of Section 48 read with Section 62 of the BNSS in the instant case, which goes to the root of the matter, making the whole arrest procedure violative of Article 22(2) of the Constitution of India. Therefore, the rigors of Section 37 of NDPS Act will not be applicable in the instant case. In view of the aforesaid findings, it is directed that the accused applicant shall be released forthwith from judicial custody on furnishing of a bail bond of rupees 1 lakh with two sureties of like nature, at least one of whom should be a government servant, to the satisfaction of the Special Judge Special Judge Karbi Anglong Diffu, subject to the following conditions. The accused applicant shall appear before the trial court as and when required. The accused applicant shall not hamper and tamper with any evidence or influence any witnesses witnesses connected with the case. Next para, in terms of the aforesaid directions, the instant bail application is disposed of as allowed.
Obliged.
Twenty-seven.
The regular bail application, already 57 days behind the bar. 57 days already completed, my lord. FIR at page number
60 days,
mandatory, my lord, 90 days.
90 days.
A few sections. Coming to this also, my lord. Page number 7 is the FIR, my lord. Allegation is that, my lord, I have been running some immoral activities in my rented house, my lord. Accordingly, the complaint was made.
Sir, I told you to write Special Judge Assam. You have written Special Judge Kamrup Metro again. Why? I have asked you to write specifically. I have stated Special Judge Assam. That's a different thing. Huh? No, it will be Special Judge Assam. You'll have to correct it again. There is, I mean, these are anti-corruption cases. This is Special Judge Assam. I've told you Special Judge Assam. You write it and correct it. No? Then you give it to me. Yes.
My lord, accordingly, I was arrested, my lord. The allegation is that, my lord, I have been running immoral activities in my rented house, my lord. This is the allegation.
Yes.
Well, already 57 days behind the bar, my lord. And, my lord, there is
Yes, CD has come. Allegations?
my lord, regarding the victims, my lord, they were in my house, my lord. Before the incident, they have never complained anywhere, my lord.
Victims usually do not complain. That is not a
My
precondition.
lord, and
They are victims of your.
victims, my lord, because they were not, their hands were not tied, my lord. Now to save themselves, my lord, I have been. both the victims, my lord, the alleged victims were handed over by the local resident, my lord. And finally, regarding their allegation, my lord, may I read, my lord, in the FIR, my lord?
FIR I have read.
Yes, my lord, it has been mentioned that the victim, the alleged victim are also caught red-handed, my lord.
Hmm?
The victim, my lord, the alleged victim, they were also caught red-handed. It has been alleged in the FIR, my lord. Now they have become, my lord, victim, my lord. So,
No, I didn't
My-
get it. What do you want to say?
my lord, I have not forced anyone, my lord. That's what I want to say, my lord.
I have not,
Forced anyone into the immoral act.
you have not forced.
Yes, ma'am. My premises was used, that I admit, my lord.
So you allowed your premises to be used.
My lord.
Okay, heard, Mr. Mr.
HL.
H. Ali, the learned counsel appearing for the accused applicant also heard Mr. B. Sharma, learned appeal for the state. This is an application under section 483 of BNSS 2023, praying for bail to the accused applicants in connection with Chanmari PS case number 57/2026 under section 443 in bracket 3/444 of BNS read with section 3/4/5 in bracket 1 bracket small a/7 of the Immoral Traffic Prevention Act, Prevention Act. Immoral traffic, 1956. An FIR was lodged, by certain informants, certain local residents, local residents. Residents alleging that suspicious and illegal activities are allegedly being carried out in house number 9 located at Poop Saranya, Byline 1 West in their neighborhood. It was alleged that local residents observed that the said premises is frequently visited by unknown persons at odd hours, causing disturbance and creating an unsafe environment in the locality. It was alleged that strong suspicion was there that illegal prostitution and trafficking related activities were being conducted, were being operated from the said house. It was alleged that local residents noticed that residents of the locality known as Nikhil Das along with Atikur Rahman are managing and facilitating these activities as pimp and operator. Pimp and operator. It was alleged that on that day, that is on twenty-five five 2026, two women were caught red-handed in the said premises, and both the accused persons and one of the accused persons, namely Nikhil Das, was handed over to the Chanmari police by the local residents. On receipt of the FIR, police registered Chanmari police station case number 57/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant has not forced anyone to do any immoral activities, and since the accused applicant is already behind the bars for 57 days, he should be allowed to go on bail. The CD in the instant case has been produced and the same is produced on perusal of the CD and after finding sufficient incriminating material against the accused applicant's involvement in the offense that has been alleged in the FIR, the instant bill application is rejected. Hmm?
Almost 75 days, Lord.
Okay, CD not received, let the matters be listed on 4th or 4th August. Same order, all this.
Yeah, please, your lordship.
Notice served. Office note does, office note
Awaited,
survey report is awaited,
awaited, your lordship.
or it was. Hmm? That was completed. Then we'll wait for some time.
Lordship,
Hmm?
lordship.
Yeah.
Amicus
We'll give a
curiae
next date. Let them come. Heard MSG Bora, the
Uh,
Learned Council.
Articles- Yeah, your lordship, on amicus curiae maybe.
No, that's what we're saying, that
No.
like we'll give them some opportunity to bring someone.
Lordship.
If they, and the next day they do not bring
Sure.
someone, then we'll give, we'll
Short
put up.
day, maybe.
Because it was, he has received today only, no? When it was executed. When was it served? When? Authorized very recently, so they'll need some time to engage someone. Heard MSG Bora, Learned Council appearing for the accused applicant, also heard Mr. K. Baisha, the Learned APP for the state. The Learned APP submits that, that he has received an instruction that notice on respondent number 2 has already been served on 18/7/2026. Taking into account the aforesaid, they let the matter be listed on 5th of July, 5th of August. Hmm? Hmm. Hmm. You please do it. Whenever you receive it, you place it.
33. And 33 and 37 may be taken after sometimes, man.
Hmm?
33 and 37, man.
Hmm.
Be taken after sometimes, man. I have informed him, man. He's
Who?
coming. My senior, man. He's the first floor, man. He was like some other court, man.
Where is he?
He's coming, man.
On the roads or on the corridor?
No, he's in the corridor, man. He was in other court, man. 34. And regarding 34, 35, 36, can be at 2 o'clock, man.
Why he's appearing in this case?
Yes, man. Yes. At 2 o'clock.
Well, then he's coming now when?
No, my lord, this 34, 35, 36 will be appeared by Mr. H. Chaudhary, man. Mr. H. Chaudhary will appear.
H. Chaudhary.
H. Chaudhary will appear, my lord. That's right. 34, 35, 36. RDA.
May I please, lordship? Lordship, my senior late court number 25, lordship. After some time,
Who is your senior?
Mr. M. Khan.
The bail petitions cannot be adjourned just like this. If the petitions are not, the councils are not there, it becomes difficult. Time passes over for time being.
Kindly pass over for time being, lordship. End of the affair, lordship.
Hmm?
End of the. FSL report also.
CD not received. CD not received, let the matter be listed on 4th of August, 4th August.
Interim may be continued, lordship.
Interim order so passed earlier shall continue till the next date of listing.
May I please, your lordship? Petitioner was in interim, my lord.
Okay, you go there.
Lordship.
We'll extend it till sometime. Heard Mr. R. Ali, the learned
It's,
counsel. Huh?
HM.
Heard Mr. H. A. Ali, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APE for the state. Reason application under section 482 of BNSS 2023, praying for granting PRS bail to the accused applicant in connection with Howley PS case number 31/2026 under sections 331 bracket 4 stroke 305 bracket stroke 353 bracket 5 of BNS 2023. The learned APP submits that charge sheet in the instant case has already been submitted by charge sheet number. And the learned counsel appearing for the accused applicant submits that that the accused applicant has been granted interim pre-arrest bail on 8/4/2026, and he has accordingly appeared before the investigating officer. Therefore, he should be allowed to appear before the jurisdictional court until that time. The interim protection should be extended. Full stop. Taking into account the aforesaid submission, the instant AV application is disposed of with the liberty to the accused applicant to approach the jurisdictional court within a period of 15 days from today until then. The interim protection granted to him by order dated 8/4/2026 shall be extended, shall remain extended. Full stop. 15 days you pay.
41.
You go there.
Yes.
Heard Mr. M.U. Mondal, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. This is an application under section 482 of BNSS, praying for granting anticipatory pre-arrest bail to the accused applicant in connection with Rupoiha PS case number 101/2026 under sections 329 bracket 3 stroke 324 bracket 4 stroke 303 bracket 2 stroke 221 bracket stroke 132 stroke 126 bracket 2 stroke 3 bracket 5 of BNS read with section 3 of the Prevention of Damage to Public Property Act 1984. The learned APP submits that that charge sheet in the instant case has already been filed by charge sheet number. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he should be given liberty to appear before the jurisdictional court for appropriate relief. In view of the aforesaid, the instant AV application is disposed of. We are disposed of with liberty to the accused applicant to appear to approach the jurisdictional court for appropriate relief, if so advised.
But on appearance, they may be released on.
They will take care. We are not in interim.
They're not in it.
So they will consider this.
Plus,
CD not received. CD not received. Let the matter be listed.
Okay, this is third time.
It's an AB application, Mr. Sharma.
This is third time. Sir.
Dibrugarh PS.
This is pending from long time. May. No, STSC Act with.
Okay, we'll give a short date. Heard Mr. U. Dutta, the learned counsel appearing for the accused applicant. Also heard B. Sharma, learned AP for the state. CD not received in the instant case. Let the matter be listed on 5th July, 5th August. 5th August.
43.
Pass over for time. Why, what happened? Let them, let the parties come, then we'll pass them.
Let's call for a cause there, case there is also. The FIR is a page 15 also.
Yes. Misrepresented, false document.
False document also, in fact, that SEBI document was found in his office. False document. It was not a false document.
They themselves are saying that it's a false document, SEBI. Now you claim that it is not forced. How can it be possible? What is there, Mr. But what is the investigation stage? How many days you have behind the bars? Or this is anticipated?
Also, custodial integration is not required also at this stage.
No.
Also, one.
No, with the allegations it's required. With the allegation it's required.
Also, another person has already been granted bail also. Can we see that order also? Page 32. Page 32 also.
Page
Page 32.
32.
Lot.
He's in a different footing. He's a brother-in-law. He just invested money. No, I mean, no bail.
The petitioner will participate also whenever he is called also.
Heard Mr. S.K. Das, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned AP for the state. This is an application under 482 of BNSS 2023. Read with BNS 2023, paying for pre-arrest bail to the accused applicant in connection with BI in bracket EO Gauhati PS case number 08/2021 corresponding to GR case number 9446/2021 registered under section 120 in bracket small b stroke 420 stroke 468 stroke 471 IPC read with sections 4 read with sections 4 stroke 5 stroke 6 of PC Act PC and MCS in bracket B Act 1978 and section 5 of APID Act 2013. Mr. Das, see, I mean, for the person who was granted bail, there was no allegations against him, and he's only a brother-in-law, and he stated that he himself stated that he has only invested money with him. So you cannot be on the same footing, okay?
We consider another aspect also. The petitioner also he is suffering from spinal thing problem also.
No, those things.
I submitted all the medical documents. He cannot travel also.
He is only 29 years old person. Then you write Mr. S. K. Das, the learned counsel, appearing for the accused applicant, submits that the accused applicant submits that another person has already been granted bail by the accused applicant in connection with the instant case, and therefore the accused applicant should be also given the privilege of pre-arrest bail. The case diary in the instant case has been received and received full stop, and the same is perused. The learned APP on the other, Mr. B. Sharma, the learned APP on the other hand opposes the prayer of bail of the accused applicant by applicant submitting that investigation in the instant case is still going on and still is in the very nascent stage, and detention and custodial detention of the accused applicant is required for further investigation in the matter. Therefore, he opposes the bail application, opposes the prayer of pre-arrest bail of the accused applicant. This court, after hearing the submission made by the respective counsel appearing for the parties, and after perusal of the case diary, is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AB application is disposed of as rejected.
I was granted pre-arrest bail, my lord. Interim order was there. I have appeared. I have recorded my statement. And my name is not in the affair. The main culprit was apprehended.
Hmm? Hmm.
No, no, no. Nelson, I am not saying. Oh. I have given my statement, my lord. Kindly peruse it, my lord.
Let him go, let him go. I mean, let him cooperate. Heard Mr. S.C. Biswas, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, learned APE for the state. And then you write, it is an application under section 482 of BNSS, praying for PRS bail to the accused applicant in connection with Bukolia PS case number 4/2026 under section 61 in bracket 2 stroke 331 bracket 4 stroke 351 bracket 3 stroke 311 stroke 109 of BNS 2023, read with section 25 in bracket 1 bracket small a stroke 27 bracket 2 of Arms Act full stop. A coordinate bench of this court wide order dated 15/6/2009/2026 has granted interim pre-arrest bail to the accused applicant, full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid order dated 15/6/2026, the accused applicant has appeared before the investigating officer and got his statements recorded. He submits that in view of the aforesaid, he submits that since he is cooperating with the investigation, the interim pre-arrest bail so granted on 15/6/2026 should be made absolute, full stop. The CD in the instant case has been received, and the same is taking into account the materials. Where taking into account the submission as well as the materials available, this court is of the opinion that the interim pre-arrest bail granted on 15/6/2026 should be made absolute. Accordingly, the interim pre-arrest bail granted on 15/6/2026 is made absolute on the same terms and conditions as mentioned therein. In terms of the aforesaid direction, the instant AD application is disposed of.
47.
CD has come.
Date may be given today's 13th from Kolkata.
cyber crime.
Mal-
CD will be required.
Malad.
We'll give a date. CD not received, letter matter will be listed on 5th of July, 5th of August.
Item 33 to 37.
My lord,
CD received.
my lord, with all respect, my lord. Here primarily, my lord, the FIR is at page 18, my lord. It relates to, my lord, IPL betting, my lord, allegedly, my lord. Page 18, my lord. It begins at page 18, my lord. Operative part begins at page 19, my lord. The kingpin possibly, my lord, so far as the affair is concerned, my lord, one Alok Jain, he is not before your lordships, my lord. At the moment, my lord.
How you got implicated?
My lord, I'll come to the forwarding report, my lord. And the forwarding report, my lord, that occurs at page 26.
No, in the FIR itself, your name is there.
Because I am a work there, my lord.
Hmm?
Alok
Subsequent
Jain, my lord.
investigation conducted that immediately
yes, my
after search revealed.
House of Alok Jain was raided, my
the-
lord.
Correct, in the involvement
These
of 40
persons were found, my lord.
persons illegal variant network.
And the allegations again us, that is apparent in the forwarding report, my lord, why we have been arrested, my lord, and we are named, my lord. That occurs at page 26. Page 26, 15, my lord. Page 26, 15, my lord. Para 15. Lordship may have found, my lord.
Yes.
I begin, my lord, during investigation, leave aside, my lord. Then thereafter, last 5 lines, my lord. There are reasonable grounds to believe that the accused persons Kamal Upadhyay, Vikas Gupta, Amit Kumar Jha, Lal Saheb Mahato were actively involved in the commission of offences under the relevant provisions of the Gaming Betting Act, my lord. And they are there for 52 days, and it's a 60-day period offense. And of course, my lord, initially when the case was registered, my lord, 111 was attributed along with several sections of law, my lord. Subsequently, my lord, lordship, kindly have a look at page 22, my lord. These sections were added, my lord.
Section 9193.
My lord, several sections were added, page 22, my lord.
Okay.
And thereafter, my lord, 112 was attributed, my lord. And 112 is organized crime, my lord. Initially, 111 was there, my lord. Thereafter, my lord, 112 was attributed. And possibly it would be an offense, apart from others, my lord, Gaming Betting Act, my lord, all 60-day period offenses. 112 would be attracted, my lord. And what 112 reads, my lord,
Yes.
with all respect, my lord.
Yes.
112, my lord, petty organized crime. Whoever being a member of a group or gang, either singly or jointly commits any act of theft, snatching, cheating, specific, my lord, offense specific, unauthorized selling of tickets, unauthorized betting or gambling. And there, my lord, with all respect, my lord, quantum of punishment, which may extend to 7 years, my lord.
1 year.
1 year or extend to 7 years, my lord, 60-day period offense, my lord. Initially, 112 was attributed, 111 was
So
attributed.
basically, all are 60 days offense.
So for, because that is why they added 111.
Hmm.
Initially, they organized, my lord, added, attributed, my lord, 111, my lord.
Hmm.
That is 90-day period offense. And apart from that, my lord, the forwarding report itself says, my lord, with all respect, I'm repeating, my lord, for the sake of repetition, page 26, my lord.
No, before this, like during, they have, of course, like later on, they have stated that Gambling Act, were actively involved in commission of so-and-so, but before that, during the investigation, it was reliably learned that arrested person so-and-so, so-and-so, so-and-so had come to the residence of accused so-and-so for participating and facilitating illegal betting activities.
Exactly.
During the police raid, upon noticing the police team, they attempted to flee and the
Yes,
spot and so and so. And all.
Yes.
Yes, Mr. Sharma, what is? No, I mean, I don't think anything else is there. Anything else is there to
Therefore,
submit?
should not be, my lord. And my lord, no, that I paid, there cannot be any, I never paid. My job is different, my lord. That I engaged in betting, my lord, with all respect, my lord. Those sort of, my lord, with all respect, evidence.
Okay,
it
let's
must
see
be
what
there.
is there in the, what is there in the CD. Hmm. The allegations are there. There is not disputed. The only thing is that 52 days. Hmm. Okay. Yes. Hundred and 12 was added later on.
No, no, my lord.
What has happened?
Exactly, my lord. Can I place it like this, my lord? One line, my lord, with all respect, my lord. As because initially, because writing good English is not law, my lord. They put 112. Thereafter, they added 111. You cannot eat the cake and have it too, my lord. 111, thereafter, my lord, during investigation. And specific allegation, we participated in gambling. If we participated in gambling, after 52 days in custody, how much money we invested or made others invest through our accounts, my lord. May are investigating till now after 52 days that, my lord, we assisted. Assistance is in which manner? We must have taken money from somebody to invest in IPL betting, my lord. Have I made my position?
No, it's not only about money, Mr. Mahajan. It's not about money. It's facilitating. You have different ways. It's not only about money. It's not only about money. Somebody is putting money. You may not be involved like getting the money or procuring the money, but you are facilitating to invest the money.
That is so, my lord. In that event, my lord, here, my lord, how much is our involvement, my lord? Mayor stating in English that our, my lord, mobile records are there, everything is there, my lord.
See, a person is organizing some gambling or this kind of activities.
My lord.
Your involvement is there because you are found there or whatever. The allegation is there.
My lord.
Now, now your investment is 1%, 10%, 15%.
If that is, my lord,
That may not be a relevant factor.
My lord, I'm not.
What is relevant is that like whether there is any organized crime or not, whether there is any this kind of illegal activities happened or not, that has to be seen. And what is the quantum? What is the gravity of the thing? Gravity of the thing. So that has to be seen. Now CD has to be produced.
My lord, lordship, definitely, my lord. Kindly see one part, my lord. If any quantum, my lord. So far as we are concerned, domestic help something, no quantum, my lord. That is exactly, my lord, I'm putting emphasis.
So we'll look into this.
Well, exactly. No, whether any monetary involvement of ours is there.
No, that's what I'm saying. Monetary involvement always may not be there.
Well, lordship would
facilitating
any quantum of criminality, my lord.
Yes, that is what I'm saying.
Any quantum of criminality. And my lord, kindly see one part. 112, just while drafting the affair, they put 112. Thereafter, 111, my lord. That is 90-day period offense. Thereafter, which is offense specific, my lord. 111. 111 is, my lord, specifically it relates to gambling, my lord. Oh, sorry, 112, my lord. 111 was initially there.
111 is organized crime.
Organized crime.
112 is specifically gambling.
Petty.
So 111 is there in the affair.
Subsequently added, my lord, meaning there by 60-day period offense. We are already there for 52 days without any monetary involvement. My lord, may be a ground, may not be a ground, my lord. And my lord, one co-accused, he bought gold because of rivalry between gamblers, my lord. This was possibly initiated. And this order speaks, my lord, with all respect.
No, tell me one thing, how you are saying that 111 was added later on?
Yes, well, page 22.
Page 52.
22, my lord.
22, what is there?
Yes, my lord. May I just read it, my lord?
No, in the FIR lodged on 162026.
Yes, my lord. 111 was 112 is not there, my lord.
No, 111 was there. So
yes.
111 is organized crime. So 90 days period.
My lord, absolutely, my lord. In the FIR it was there. Subsequently by page 22, can you see, my lord? They added these sections of law, my lord.
They added into the FIR, right?
Then why they added 112, my lord? Because 112 is offense.
112, maybe some of the persons may be involved in maybe
exactly, my lord.
Maybe 112.
Kindly see, my lord. Kindly see 3, my lord. Their prayer, page 22.
Correct. So there may be certain people like who are only involved in gambling. They
No,
may
my
not
lord,
be there. They may not be facilitating the crime.
No, facilitating,
See, facilitating is different
my lord,
and
facilitating gambling on, it will be lesser offense, my lord.
Hmm.
No, kindly see, my lord.
Facilitating organized crime.
Exactly.
Your
my lord.
involvement is alleged to be facilitating organized crime,
Organized-
not in gambling only.
My lord, I may be wrong, my lord. Lordship would kindly bear with me. What 111 says, my lord? Because, my lord, intention of the legislation.
Yes,
reflected in the
111
section,
says
my lord.
what? One says what?
Absolutely regarding gambling,
Ah.
my lord. So
Yes.
112 is high level organized crime.
111 is organized crime.
Exactly, my lord.
112 is petty gambling, petty offenses. So that
Absolutely, my lord.
gambling comes under that.
That is why
Correct.
that 112.
So there may be certain persons who may be involved in who alleged to have been committed offense under 112, but not all. So that is why 112 has been added.
My lord, we were arrested persons, my lord.
Correct.
And we were arrested 111. What 111 reached, my lord? Absolutely a different story, my lord. First line.
One says
Whether
organized
lordship will
crime.
see
Hmm.
whether materials of 111 are there or not. It is only, it relates to gambling, my lord. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft,
Economic
extortion,
offense,
land grabbing,
cyber
contract
crimes,
killing, economic offense,
cyber crimes,
cyber crimes. Correct, my lord.
all these things are
Correct. But now, my lord, it is not defined in gambling 111. 112, it is specific, my lord, offense specific. That is my prayer, my lord.
Okay, we'll pass order.
Mine,
We'll
mine.
look into it and pass order.
And there is one co-accused was granted the
Other case?
same, my lord.
Same.
And number one co-accused was granted the privilege of bail, my lord,
Okay.
because the prime accused, he bought gold from him, my lord. By this honorable court, my lord.
Prime accused got some gold from him.
Exactly, 80 lakhs, 90 lakhs. He is not before your lordships, my lord.
Okay.
My lord, this is visualization, my lord. This has to be content, my lord. With all respect, my lord.
Okay, we'll pass the
My
order.
lord, my lord.
Yes.
Simple and humble prayer, my lord, in respect of item 47.
Hmm.
Fixed for the 5th August, my lord. Kindly before then, my lord, any date, my lord, on 27, if it possible, my lord.
Not possible 22.
As per our,
Fifth fix.
as
So
per our information, my lord, CD already sent from the PSB. So
let it come.
any date before
Okay, third of which item?
31st, my lord.
Which item?
Item 47.
47.
31st.
47, make it 3rd July. Sorry, August.
The diary was called for, I was in interim, my lord,
Okay.
and I was directed to appear. I appeared and gave my statement, and from the earlier order sheet, if your lordship will peruse, it's purely a civil dispute, which is sought to be converted into a criminal dispute, if your lordship will see, and the second page of the last order, my lord. Order dated 19/6/26. On perusal of the FIR.
Okay.
Second page, it is clearly observation is there, mother. I was an employee, mother. There was an agreement between the parties.
Okay, we will let him go in this matter. Heard Mr. J. Kamada, learned senior counsel, assisted by so and so, preparing for the
Yes,
accused,
Lordship.
preparing for the accused applicant. Also heard Mr. K. Bosho, the learned APB for the state. This is an application under section 482 of BNSS 2023, paying for granting pre-arrest bail to the accused applicant in connection with Gulagat Police Station case number 190/2025, registered under sections 61 in bracket 2/314 bracket stroke 316 bracket 2 stroke 318 bracket 4 of BNS 2023. The allegations as narrated in the FIR.
Wait.
FIR dated 7/10/2025
Yes.
to 7/2025 reveals that the accused applicant is an employee of a firm, namely Bill Solutions, which has entered into an agreement with the informant's company to set up a solar plant, and pursuant thereto some payments were also made to the executing firm, but due to lack of sufficient progress in the execution of the work, the informant had lost lost the FIR, alleging cheating, forgery, and criminal breach of trust. The CD in the instant case is yet to be received. However, the Lorded Senior Counsel submits that the allegations made in the FIR transpires that the dispute is basically of civil nature, and the same has been given a color of criminal offense. He further submits that the accused applicant was given interim protection by the order dated 19/6/2026 by a coordinate bench of this court. And in terms of the aforesaid interim protection, the accused applicant has already appeared before the investigating officer and got his statements recorded. In view of the aforesaid, he submits that since the accused applicant is cooperating with the investigation, the accused applicant should be and the order dated interim pre-arrest bail order dated 19/6/2026 should be made absolute. Full stop. Taking into account the aforesaid submission, as well as on perusal of the materials brought before this court by way of filing this AB application. This court is of the considered opinion that the interim pre-arrest bail order dated 19/6/2026 should be made absolute. Accordingly, the instant AB application is disposed of by making absolute the interim pre-arrest bail order dated 19/6/2026 on the same terms and conditions as mentioned in the order dated 19/6/2026. Disposed.
22.
Yeah, please, Lord. Actually, it's arrested on 23/9/2025.
23?
23/9/2025. From LG Airport, Gauhati Airport. Under section chip 20, subsection B to 21, 22C, 23C, 29/60 of NDPS Act. The allegation against him that some contravened items seized from the allegation against the accused that he's traveling from Laos, Lordship, to Gauhati International Airport. And some suspected items was seen during the
Yes.
Almost 302 days I'm in jail. Also,
What is the stage?
what's it?
What is the stage now?
This is lordship.
Consideration of charge. Hmm? March 23, 2003, 203, 2026, charge frame. Okay. Now 23, 2023 was final complaint. Quantity is quite huge. Yes, what is your ground of, because section 37 is there, you are aware of this? What is your ground for prayer of bail?
That in the late night of 22/9, I was detained custom officials from LGB airport, and I was produced before the honorable court on 24th at late evening at 5:30 p.m.
You were detained at what time?
Lordship, at late night of 22/9.
Late night of 22?
9, 2025.
Hmm.
Almost Lordship 23. But the whole day of 23, I was detained by the custom official.
In the evening, you were.
Next day, Lordship, on 24th evening, I was produced before the court.
23rd evening.
24th evening, Lordship.
24th evening. You were arrested on 23rd
In the starting of 23rd, Lordship, almost. Detained in, I was taken to a Lordship 11 p.m. of 22/9/2025. The whole day of 23 is
11 p.m.
Lordship.
of
22.
22 and 22/6, 22/9.
22/9.
And you were produced on? Produced at?
Produced at 24.
24 what time?
24/9 at 5:30 p.m. 5:30.
Mr. KL, I mean, Page 19. How are you saying that you were arrested on 22?
Was it detained, Lordship?
Hmm?
Detained by the custom official.
At what time? From which document you are saying so? Is there any document to say so that you have detained on 22nd?
Lordship, page 12, Lordship. And also the case number, Your Lordship, custom case number 22/9/2029, case number so and so NDPS LGBI dated 22/9/2025. Is page 11 that clearly shows the dated of the case number registration date. Case registration date is 22/9/2025, Lordship. Page 11.
The page 13 says approximately at 1:30 hours 2309. So you have taken him under control. Hmm? No, that you have stated, but you have detained him at 1:30 hours on 23/9.
2025.
That is true, but Supreme Court says otherwise. No, that is already decided by the Supreme Court. No, I mean this that other case. Hmm? Delhi Enforcement Directorate versus that case we have referred.
Subhash Sharma.
Subhash Sharma's case. Subhash Sharma's case is clear. That Niranjan Singh's case, those cases are there. The formalities you can undergo, but I mean, so there the Supreme Court has decided as to which is the time from where it has to be counted. And there it has stated in the similar case, Subhash Sharma case is similar, that he was arrested, he was taken under control by the customs official in the IGI airport. That's what I mean. When you detain somebody, that means he is under your control. So and if he under control, whether he is in custody or arrest, Niranjan Singh's case says that like if you use different words, doesn't make any difference. So once you detain, that means he is under your control. His personal liberty is curtailed. So once you have done so, then within 24 hours is the main is the mandate given by Article 22(2). Correct. So now, Now, in all cases, what authorities have to undergo. Now, in all cases, authorities have to undergo certain formalities. Now, in NDPS also, I mean, the last case like this, same thing happened. No, para 11 I have read. In many cases, arrest memos are given quite later on. The person is detained at one time and like arrest memos were issued in the separate time, different time. And only because the arrest memo says different time, that will not be sufficient. The court has to see like at what time he is been detained. That is the law laid down by the Supreme Court. NDPS, I'm talking about NDPS. This Subhash Sharma's case is NDPS. These other cases are super NDPS. Enforcement Directorate. I mean, but and that is Enforcement Directorate. But in NDPS case also the same thing will apply. Why not apply? Why will not apply? Now, is there anything that Article 22 has been separately defined under NDPS Act in arrest? Where please show me the provision? Please show me the provision where NDPS Act says that. No, in NDPS case, that case has to be taken up differently. It has to be treated differently, and 4 hours will not be applicable in NDPS case. Then Supreme Court has already settled the issue, saying that from what time the time will start running. You show me a case. Show me a case. No. I mean, the Enforcement Directorate case that has been specifically, Supreme Court has specifically said from what time this is to be counted. The NDPS, how can it be a separate timing? That's for 24 hours. So 24 hours, and in Niranjan Singh's case, it has been decided. Where? Where Article 22 to 22 can be relaxed, said by give me a case. No, give me now. I mean, like, if you're arguing that thing, I mean, 22(2) can be relaxed. I mean, in all the cases, PMLA, everything cases, 22. I mean, the Supreme Court has not said anything about Article 22(2). How can it be said? The Constitution can be. Okay, we'll take our. দুটা কেস রেফার করেছিল না ইউসুফ মানানোর কেসত এই যে লাষ্ট কেসটোত অৰ্ডাৰটা দিলে হয়তো চেম্বাৰতে আছিলে বোধ তাতে দুটা কেছ ৰেফাৰ কৰা হৈছিলে কিন্তু কোনে ল'লে অৰ্ডাৰটো কামতে থাকিব এই লাষ্ট ইউসুফ মানানোর কেসটো যে আছিলে মই অলপ আগতে জাজমেণ্টটো চাইন কৰি আহিছে তাতে দুটা কেছ ৰেফাৰ আছে ইউসুফ মানানোর কিমান নম্বৰ কোনে ল'লে চোৱাচোন তাৰ মাজত চিন্তা থাকিব Yes.
Can I, Lordship may kindly take up
It has come.
35 and 36 initially, my lord. 35 and 36 together, my lord, on same point, my lord. That's why, my lord.
35 and 36, 34?
34, last I will do it, my lord, kindly, my lord, because 35 and 36, my lord, on the point, my lord, that custody and 24 hours, my lord. Here, page 13 is the FIR, my lord.
So you are also arguing this
Yes,
point only.
Yes, because here what has happened, my lord, during the, my lord, initiation of the whole case, my lord, 2 persons were injured, my lord, in firing, my lord, by the police, my lord. Thereafter, they were taken to, my lord, that admitted in hospital, and subsequently they were produced after expiry of 24 hours, my lord. Page 13 is the FIR, my lord. There was some demand made to the informant, my lord, in the name of a bank. Page 13, my lord. Of item 35, my lord, G2 Moon. Page 13 is the FIR, my lord. It was lodged on 24/5. Lord should see the kindly the date, my lord.
Yes, then
Thereafter, Lord, may I kindly see the forwarding report, my lord, of the accused, my lord, page 26, my lord. There, Lord should find that it is dated 29/5. Lord should seen, my lord, top right-hand side.
yes.
And now, Lord, may I kindly see the grounds of arrest. One, just the next page, my lord, the time would be relevant, my lord. There, Lord, page 27, Lord should find, my lord, that on 25/5/2026, Lord should seen, my lord, at 3 p.m. So, my lord, the whole incident allegedly, alleged incident, it took place at 25/5, my lord. And Lord should, thereafter, Lord should find, my lord, that as a result, in self-defense, Lord should find, my lord, Ritu Gogoi and Jitu Moni Gogoi, my lord, Lord should seen, my lord, sustained bullet injuries, my lord. So incident occurred, my lord, 25/5, my lord. They received bullet injuries, my lord. The investigating agency, my lord, took both of them and admitted them in hospital, my lord.
So at 3 p.m. they were arrested. He was arrested.
Detained, yes, my lord.
Correct. Then
Yes. Now, Lord, should kindly see the medical reports, my lord. It start from page 20, my lord.
hmm?
Page 20.
Now, when he was produced,
He was produced that day, my lord, 29th, my lord. That forwarding you have shown, my lord.
29.
Yes, and the order also we have annexed, my lord.
Hmm.
Where it starts
Yes,
from
29. Arrested on 20.
9,
Arrested on 25.
29/5, my lord.
No,
But-
arrested when?
He has been detained, my lord, since the time of occurrence, 25/5/2026 at 3 p.m., my lord.
Hmm.
So he was detained, he was taken to, my lord, that hospital, my lord.
Hmm.
And thereafter, he was produced only on 29/5/26 on his recovery, and that Lord should find, my lord. The forwarding report is also dated 29/5, Lord says seen, my lord. Page 26, my lord.
Yes, 29.
Now the order also we have annexed, my lord. It starts from.
29.5.
Yes, my lord.
Hmm.
Page 30, Lord should kindly see, my lord. It
Hmm.
starts from page 29. IO so-and-so has last line, my lord. Then first line of page 30, so-and-so produce accused Jitu Moni Gogoi before me, Lord should seen, my lord. Page 30.
Page 30, the medical officer made a report.
Lordship. Lordship.
Yeah, you're showing which one? The medical
Lordship,
officer
no,
report?
my lord, that 1842, my lord, petition. I'm sorry, my lord, that.
Huh?
There are three applicants, my lord. Page, I am.
1842 only.
Yes, my lord.
Page 30, which paragraph you're showing?
First line, my lord.
First line has produced a
Yes,
so and so before me under arrest.
Yes.
Along with so and so forwarding
Yes,
report.
that is
So-and-so.
on 29, my lord.
29, yeah,
Yes,
that is there. That
Yes,
is there.
now kindly have a look, my lord, at the medical reports, my lord.
Hmm.
Page 20, my.
Page 20.
Yes, my.
Yes.
Page 20, Lord should find, my lord, that First, my lord, that first lines, my lord, word, my lord, jail, sick room, lordship, seen, my lord. Left-hand side, top, my lord.
Jail sick room.
Yes, my lord. Jitu Moni Gogoi, so and so, my lord. Then date of admission, 25/5/2026. Date of discharge, 28/5/2026. Then, my lord, alias history of police injury or police firing, my lord. So instead of, my lord, they did not produce him before the court because of treatment. Yes, they can do it, my lord, but they should have, my lord, forwarded a report to the learned magistrate stating that during this incident, they were injured, so they were admitted in hospital and they will be produced when after recovery. And even in that, my lord, the learned magistrate would have or should have, my lord, seen him on VC or make a person.
Where is the provision?
My lord, there is an order passed by this honorable court, my lord. Because
Is there any statutory provision?
statutory provision not there, but 24 hours, how to make out that 24 hours? Because
What
otherwise,
Supreme Court says?
Supreme Court says in 24 hours he has to be done, my lord.
Yeah, correct, but like if somebody is if somebody is taken to the hospital,
Yes.
in that circumstance, what has been said?
But that part, my lord, it is not yet decided, my lord, subject to correction, my lord.
Mm.
But here, my lord, kindly see, my lord, he is in detention, he is in custody, either by police or either he tried to flee away, whatever be it, my lord. But he was in custody and in that Niranjan Singh Lordship I already mentioned, my lord, it is there with me also, my lord. So what is the meaning of custody that has been defined there under duress or under authority of law or by allied authority, whether it is police or allied authority? Here by the, my lord, taken by the police, he was there in hospital. So hospital definitely, lord, you see the diary, there was police there, my lord. And he was, it is not that he was a free
No,
man.
where is the provision of saying that like if somebody who is injured
Yes, my lord.
during, while he was tried to be arrested
Yes,
and
my
he got seriously injured,
Yes,
and
my lord.
in that situation,
Yes, my lord.
if he had to be taken to the hospital
Yes,
and he stayed in the hospital for 10 days,
yes, my lord.
then what is the provision?
Because kindly see, my lord, here, my lord, what is, my lord, that the injury, whenever there is an injury to an accused person,
Mm.
my lord, he is provided the, my lord, that, my lord, the treatment as per the BNS, my lord.
Mm.
Because here, my lord, kindly have a look at, my lord, 50, just I'm taking 1 second. 56 and 58. 56, my lord.
58 says something.
Yes, 56, my lord. Kindly
56 or 58?
56 first, my, I'm showing because as per BNS 56, my lord, health and safety of arrested person, my lord. 56 first, my lord. It shall be duty, lord shall find it, my lord.
1 second. Yes.
So it shall be duty of the person having custody of an accused to take reasonable care of the health and safety of the accused.
Correct.
So here the health and safety of the accused was taken care by the investigating agency. He was taken to the police, my lord, my lord, that medical, my lord. And he should have, my lord, been, since he could not be produced, there has to be a report, my lord, because there has to be a remand order passed by the learned magistrate under 187, my lord. Otherwise, my lord, in every case, my lord, the police will do what they will take him to hospital, they will admit him, and they will say he has not been formally arrested, we will arrest him subsequently to keep him in detention, my lord. So 56 is there, and then 58 lordship already seen, my lord, and
No, that these provisions this court is aware of.
my lord,
But only thing like we are asking
my lord.
is there any statutory provision or is there any
Judgment.
principle or principle or ratio laid down by the Supreme Court in this kind of facts, wherein the person has to be taken because if the person is not taken to the hospital, he may die.
Right.
So he has to be given
Yes, yes, yes,
proper this thing.
Definitely.
So if he has taken to the hospital, what is the formalities? What is the procedure that is followed by the Supreme to be followed by the police
my lord,
officer?
to be
So
fair
where
enough-
is that?
Yes, to be fair enough, on that point, my lord, direct judgments I have not found, my lord. But my lord, what is the procedure followed here, my lord,
Mm.
is that, my lord, the investigating agency, they file a report before the court. But that has to be there, my lord, because the incident occurred, they has to file a report before the court. So this incident occurred today.
So they have
This-
filed a medical report.
They filed a medical, they produced the other accused, but they did not say about these accused.
Hmm?
When the other accused were produced on that day.
Hmm.
So what they should have done, my lord, that these two accused has been produced before this court, but the other two accused, they have been admitted in hospital and they will be produced before this honorable court upon their recovery.
No, that is, that is one thing that they should have ideally
Yes,
done.
yes, yes, yes.
But if they have not done it, like, is
Yes.
there any violation of whether,
Yes.
whether any, I mean, ratio has been led by any court saying that if that is not followed, then that is a violation.
My lord.
Whether that has
but,
been said, and after discharge within 24 hours, he has been,
he has been produced.
he has been produced.
Yes, yes, yes.
So that is the thing that,
Yes.
so to I mean, give a finding on that, is there any solid law?
My lord,
Is there any cases, or what is there?
our high court, there is one judgment, my lord, where it has stated that there, my lord, person was.
No, where is that, our high court?
But there, what happened, my lord, the person was arrested, he was taken to the hospital, but he was never produced, my lord.
That's a different thing. He was never produced before that.
Yes,
before
yes,
that.
he was never.
No, but in
Yes,
case of,
sir.
but in your case, he hasn't produced. But only thing is the time gap, right? That the period he was in the hospital.
Yes, ma'am.
What happens to that?
But yes, my lord, what happened, my lord? Here, my lord, in that case, my lord, also, my lord, what happened, my lord? The person was arrested, then he was injured, my lord. So what the investigating agency, they made the arrest memo, but they never produced the person before the honorable court. So this honorable high court has stated that, my lord, in such situation, the person should have been produced before the court through VC, or the learned magistrate should have himself gone to the, my lord, medical, my lord, hospital to say ascertain the fact, my lord. So here, my lord, neither arrest memo is there, no report was submitted before the court. And in one, my lord, order.
Where is the case? Let me
Yes.
see.
Because Niranjan Singh Lochia always seen there, say it's, my lord, what is custody, my lord? He was under duress. He was not in a private hospital. He did not went to the hospital.
He was, it was compelled, he was, I mean, this police was compelled to take
Yes.
him to the hospital because he was fleeing.
Understood, my
He
lord.
was fleeing and he had to be stopped by.
Understood, my lord.
Correct.
Understood, my lord. But my lord,
So in that case, whether that will be
my
custody
lord,
or.
one person will be in hospital for 100 days, suppose, my lord.
Hmm.
Will he be kept there as a?
He will not be. That is the usual product. Ideally,
Yes,
it
yes.
will not be.
Because
But-
here, my lord, the police took him, my lord. He did not went to a private hospital and admitted.
But if police would not have been taken, you would have been probably in heaven.
But law, my lord, that I understood, my
Then-
lord. But the report, my lord, should have been before the court, my lord.
Correct. So I mean, that is ideally that is the position. Correct.
That
Ideally,
should have been done, my lord.
ideally that is expected.
Yes, my lord.
But now thing is that, is there any law says so? I mean, you'll have to show a law which has been violated.
No, he-
Ideally, something should have been done.
No, he is in custody, my
And
lord.
that's a different thing.
No, he is a custody, my lord.
No, he is in custody. How can you say he's in custody?
No, police took him, my lord.
Police took him because he was injured, because
Understood,
he was
my lord.
fleeing.
There has to be a report, my lord.
Otherwise, police would have left him there only.
They
Go
cannot
wherever you want to
it.
go.
They fired upon, my lord. Kindly see, my lord. They fired.
They fired upon because you are fleeing.
No, I understand, my lord, but that is the merit of the case, my lord.
No, that is the merit of the case. That is, prime facie, that is there.
My lord.
That merit will be decided in the trial court.
No, my lord, here I am not submitting on merit, my lord. We are
Yes,
submitting.
yeah, correct. That is what I'm saying.
Yes,
I
ma'am.
mean, we'll have to see what is there prima facie.
My lord.
Correct. The prima facie, the allegations are that while you were taking the money, police went to the spot in civil dress and you tried to flee. Then you have been shot. I mean, they have to fire a shot at you, and then you got
My lord,
injured.
my lord, may I ask my learned colleague, my lord, in the diary, it will be there that they have been admitted. They have been taken and they have been admitted by the investigating agency, my lord.
See, there is no doubt about this. What this court is asking is
I
only
understood, my lord.
thing is that, like, whether there is any procedure laid down
Procedure,
in
my
any
lord,
of the provisions.
procedure is not there, my lord. Definitely, my lord. Because he has been given treatment under BNS 56. So BNS would be applicable. 58 would be applicable. Their lordship would see, my lord, that yes, para 13, they have prepared the arrest memo, my lord, but there was no order passed by the learned magistrate, my lord. Case 13, my lord. para 13, my lord. Now, my lord, regarding that 14 and 15, regarding that, what will be happen when the, my lord, person is in hospital, my lord? In para 15, it states, my lord. Page 6, my lord, that from start, my lord, that of para 15, my lord, there may be exception.
Yes, Mr. Sharma, what do you have to say? We are not concerned with, Mr. Sharma, we are not concerned with the other two persons. We are concerned with the person who is before this court. Please address about him. Whether you have intimated the magistrate, whether any report has been made. Made, and whether it was sent to the magistrate within some time or within 24 hours. See, Mr. Sharma, Mr. Sharma, 187 CRPC. 187 CRPC says that a person cannot be detained beyond 24 hours without an order of the magistrate. In this case, the person is supposedly detained by the police beyond 24 hours because he was in the hospital. So without a power of, without an order of the magistrate, how can you detain him? That is the question you need to answer. Whether you can detain him because he's in the hospital, but he's under your custody. Correct. So now whether you can do it. No, 47, 48 notice was not given. You are now admitting that like 47, 48 notice also not given. No, correct. I mean, we are not bothered about 47, 48 because he's not arguing this thing. We are arguing on a point. We need to decide on a point whether in these circumstances, fact circumstances, whether he can, without producing him before the court or intimating the court or any order passed by the court, you can detain him in a hospital or not. That is the situation. Whether there is any report, there is any kind of intimation to the or any order has been passed. No, what is that? What does it say? It was prepared when? Correct then? Correct.
Apprehended.
And memorandum of observation was submitted to the court? No, you write, the police write some memorandum of observation or whatever, note, remarks, whatever. How does it help? That is the facts of the case. They are narrating what has happened. Correct. That is we are least bothered with this. Provided if you can bring in some material saying that in terms of 187, in terms of section 58 of BNSS, something has been done, and that something is substantial compliance or compliance of 58 and 187. Can you show something like that? We will post it on day after tomorrow. Let him see.
My lord.
Let him see, and you also check up
I'll check.
if there are, because I don't think there will not be any case like this. If there are so many cases happens like this.
Directly, we haven't found.
I think there will be some. I
And
mean,
in-
there will be instances wherein somebody has to be taken to the hospital, and the person could not be produced before
Yes.
24 hours. And in that
What is to
circumstances,
be done?
what procedure has been followed?
My lord.
You bring in some material,
I'll try, my lord.
then it will be better, because it's a new thing that has
Yes, ma'am.
come to
In
this
fact,
court.
my learned colleague, he stated apprehended word, my lord. No, taken or and Niranjan Singh, Lochit Singh, my lord.
No, I mean, you may be right.
Right. Understood,
I'm not saying that like you are not
Is there
right.
something on that? Point? I understood, my lord.
But in these compelling circumstances,
Yes, my lord.
what police faced at that point of time,
My lord.
because they could not produce him before the
Yes,
this thing magistrate because of his injury. So in that circumstances, what can be done?
Yes, ma'am. Only one, in the next case, if you're, to be fair, ma'am, next case, if your lordship kindly have a look at page 28, my lord,
Hmm.
regarding the other co-accused, my lord,
Hmm.
he was in hospital for a far more period, my lord.
So he was also arrested same day.
And what, no, my lord, subsequently, what the learned magistrate passed while passing the order, what it said, page 28, my lord, of the other co-accused. Day after tomorrow, I'll again show it, but just to give a look, my lord, page 28, lordship kindly see. That
Yes.
order was passed on 26/6, lordship seen, my lord, page 28.
Yes.
It is it is pertinent to mention that the IO has formally arrested.
No, one second. Page 28.
Yes.
28.
Next case, madam. I'm sorry, madam.
Oh,
36.
But so 36. Oh, it's there.
Yes. What you kindly see, page 27. That is when that accused was, my lord, produced, my lord. Page 27.
Yes.
The last, my lord.
Hmm.
My lord, kindly see, but it is noted that the inspection so and so accused is post-operation on right leg staple present. Next page, my lord. He has a bullet now, my lord, that second para, page 28. It is pertinent to mention that IO has formally arrested the accused 4:30 am on formally arrested. So there is no concept of, my lord, informal arrest and formal arrest, my lord, as per Niranjan Singh. Because otherwise in each and every case, they will say, we have detained him. That formal arrest, that's just to show that.
Yeah, understood. So we will fix it on day after tomorrow.
My lord.
And if Mr. Sharma, you be prepared.
Even in that lordship statement, that enforcement case, my lord, that so and so was detained at 11 a.m. Detained.
So detained is whether custody or arrest.
Yes.
That has been clarified in Niranjan Singh's case. Say that playing with the words will not do once the
Yes.
person is under your control
Yes.
or police's control.
Yes.
That means he is under
Yes.
you, and that means from that time has to be counted.
Yes, definitely.
All right. Or like if there is some material saying that although he was with us, he was allowed to go to
Exactly.
other place, and
Then
then he has come back again. We have called. That's a different thing.
Note in the
But
document.
once you have detained him for investigation, for inquiry, for statements, whatever,
Yes.
from that time, the time starts running.
Yes,
That is Niranjan Singh case.
absolutely.
Then you read these cases and come back on day after tomorrow. Let these matters be listed on 24th. On 24th, all these cases.
34, 35, 36.
Engineering কিমান আছে? Engineering কিমান আছে? What is it? Mr. KL, you want some time? What is that? Call this number.
22.
Which case? Huh? Where is the case? And for the question concerning the code of constitutional code, implementation under special status where people prolong detention and special effect. Therefore, they are different. We do not wish to debate on the issue further. Saying it except they do not deal the paramount consideration is nothing but special justice. For all, would there be any conflict between the sovereignty of country and liberty? Without there being a problem to say debate, particularly when one is against the Russia, and he inform of the supply of drugs. Now, what is the facts of the case? It is long incarnation. It is not about like 24 hours. No, then how this case is applicable? No, it's a special act. 37 rigors is there. This is known to everyone. But thing is that here 36 rigors is different thing, specially included in the special act, NDPS act. That's a different thing. In that circumstances, in that case, whether long incarnation and other issues can be discussed, that those things have been referred. But here the case, the facts of the case are different. But see, but Article 22(2) and 58 NDPS Act also 58 is not applicable. It doesn't say so. Section CRPC is read along with NDPS Act. Correct. CRPC will be applicable. 62 will be applicable. 62 may not be applicable, but other things are applicable. 62 is also applicable. Then in that circumstances, 24 hours rigor. That is the 24 hours mandate. That 24 hours mandate has not been stated here. Here, see, yeah, I understand, Mr. Kayal, but Mr. Kayal, it says about question concerning approach of constitutional courts in bail matters under special statutes, where Article 21, prolonged incarnation. So Article 21 is is little bit different than Article 22. 22 and 21 is little bit different. There are some differences. 21, prolonged incarceration and statutory restrictions intersect. So statutory restrictions means 37. A statute provided this. Now, because this case discusses about 37. That is why this has been, because if there is a prolonged incarceration and 37 says that there is, that two conditions have to be met. So the statutory restrictions are there. So in that circumstances, what is to be the approach of the Constitutional Court in bail matters, that has been referred to the Supreme Court, right? Sorry, to the constitutional bench. But in this case, there is an allegation of violation of 22(2). 22(2) is different. No, that correct. But the thing is that this is, see what is the language of Subhas Kumar's case. There he is saving. See, the requirement of clause 2 of Article 22 has been incorporated in section 57 of the Code of Criminal Procedure, which is 58 now, BNSS. There is no inconsistency between the provisions of PMLA and section 57 of CRPC. So PMLA is a special act, correct? Hence, by virtue of section 65 of PMLA, section 57 of CRPC applies the proceedings of the PMLA. Correct. Once the court, while dealing with the bail application, finds the fundamental rights of the accused under Article 21 and 22 Constitution of India have been violated while arresting the accused or after arresting him It is the duty of the court dealing with the bail application to release the accused on bail. Very clear. 40? No, it says about something else, Mr. It doesn't say about, it doesn't say about. Mr. Kayal, see, here the issue was totally different. Issue was, there was some conflicting views regarding long incarceration under the NDPS offenses. Correct. In that circumstance, at 30 rigors of 37, whether 37 will be applicable, not applicable, what will be the length of the period of incarceration, all these things were discussed. So the issues were different there. So in that circumstances, Supreme Court passed this order saying that there should be consistency. So it was referred to the constitutional bench, because long incarceration is one thing and section 37 is one thing. And if for long incarceration, in spite of rigors of 36, section 37 is there, bail has been granted in by one court, and another court has said no, bail cannot be granted. In that circumstances, the matter was referred to the Supreme Court constitutional bench. So here the issue is totally different. This is not pending before the Supreme Court. No, I mean, that is not, that your, yeah, I mean, that your argument will not. But you argue on something else, that's a different, but that this cannot be, I mean, this case is not, I mean, relevant for the purpose of deciding this case. No, 22 have seen, 22, nothing has been stated. It says that, see, why are you relying on 22? You read the whole case. You read the whole case. You read the whole case. You start reading from the beginning, whole case. Then totally different. So if that in that circumstances, the issue was sent to that. Why it is relevant to this case? That's what I'm asking. 22 says about 37, because you'll have to read the whole, because you'll have war against drugs they have stated. That's why, because war against drugs stated, because 37 is there, because it's a special act. But it doesn't speak anything about Article 22(2). Correct. Correct. So if you read the whole case, then the issues are different. Issues are different. Then how this case will be relevant to this case? Now, that is why you cannot read a particular paragraph without reading the whole. This is not the way to read a case, Mr. Kayal. There is nothing called formally arrested. That has been clarified by the Supreme Court. There is nothing called arrested or formally arrested. Is it defined somewhere, formally arrested? Which one? You have filed an SLP in this? Then what? No, 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 no. I mean, you are, but I mean, till this moment, you did not say that you have filed an SLP wherein the issue of counting from what time to what time has been, I mean, has been an issue. Okay, bring it on day after tomorrow. Bring it on. We'll post it day after tomorrow. Under prayer of Mr. S.C. Cal, the learned counsel appearing, counsel appearing for the Customs Department, let the matter be listed on 24th.
May it please the Lord. The petitioner applicant before your lordship has under the Moriani PS case number anticipated bail application Moriani PS case number 33. He was granted the interim bail earlier.
Let him go, nothing is there. Busho, what is there?
So there is a fine. The applicant is an lordship, applicant is an registered vendor under the visual.
বাকি আছে এডমিশন কত হাতটা এডমিশন স্কিপ কৰিব পাৰি Let him cooperate, Mr. Busho. He's already appearing on small amount. Allegation is also not very grave. Heard Mr. Heard Miss Dr. S.R. Nasir, the learned counsel appearing for the accused applicant, also heard Mr. K. Busho, learned AP for the state. It is an application under section 482 of BNSS 2023 for granting pre-arrest bail to the accused applicant. In connection with Moriani PS case number 33/2026 under sections 316/318 of BNS 2023, read with section 66 bracket C of the Information Technology Act 2000 corresponding to GR number 75/2026. GPay, he made some money that, I mean, that's petty crime, he is cooperating. The allegation against the accused applicant in the FIR. FIR was lost when?
FIR was lost lordship on 13/23.
13/4/2026. 26 of the allegations made in the FIR dated so and so against the accused applicant is that the accused applicant has misappropriated an amount of rupees 1,16,200. 200. It is also 200 full stop. It is stated. It is stated that The accused applicant had already returned around 92,000 rupees to the authorities through GPay, to the informant authorities, to the informant. To the informant, so and so. The coordinate bench of this court by the order at 22/6/2026 has granted interim pre-arrest bail to the accused applicant. And in terms of the aforesaid order, the accused applicant has already appeared before the investigating officer and has got his statements recorded. Taking into account the aforesaid facts that the accused applicant has already is already cooperating with the investigation, this court is of the opinion that the interim pre-arrest or bail order dated 22/6/2026 should be made absolute. Accordingly, the interim pre-arrest bail dated 22/6/2026 made absolute in the same terms and conditions as mentioned therein. In terms of the aforesaid direction, the instant AV application is disposed of.
Keep your vote.
And 38.
May I please, Your Lordship? This is a suspected case, and petitioners are behind the bar for lordship 123 days as on today. Well, the petitioner number 2 has already been granted bail on the ground that the charge sheet has been filed under the available section in respect of the petitioner number 2. So while lordship case report was called for, she has been granted bail. And lordship FIR, your lordship may kindly come to page 8. Our name is not in the FIR.
Hmm?
Four different persons. Why we are arrested, lordship? That is, your lordship will find at page 16, the forwarding report. Last paragraph, page 16.
So your husband and wife,
My lord.
who has been granted bail,
Tarifa Begum, second.
wife has been granted bail,
Bail by this honor.
interim bail or bail?
No, absolutely, because such sheet is filed under bailable section in respect of
Okay.
petitioner number.
Mm, mm.
Page 16, last paragraph, during the course of investigation. This is the reason for which lordship, in fact, lordship, both this FIR name accused and the victim lordship, they are the colleague of the present petitioner number 1 lordship.
Hmm?
They used to work in Meghalaya lordship, they are neighbors. They came together to the house of the petitioner number 1 lordship, accordingly stay there. And they are not aware that that the victim was lordship kidnapped. Subsequently, he has been released.
He is a daily wage laborer.
Yes, lordship, daily wage labor.
And this, the Black Scorpio belongs to whom?
Lordship, the facts, in fact, this 4-person lordship, FIR name accused, they are lordship from Kasar. And victim was also Kasar. And the incident lordship that has been taken place, that is in the district of Porigao, in the residence of the petitioner number 1 lordship. And that incident lordship was beyond the lordship outside of the house of the petitioner. Lordship now 123 days behind the bar. Lordship, charge sheet has been submitted under section 142. That is kidnapping or abducting in order to murder or for ransom. Here in the case, the demand was ransom. So, and in this case, lordship, I have another important ground that no ground of arrest was served to the petitioner. In fact, lordship, one WT message was served through another Lahorigarh police station. That is also in English language, not in vernacular.
and that is not the notice under section 47. Page 18. Page 18 lordship is the WT message.
Hmm?
Page 18 is the WT message that has been given to lordship OC
To-
Lahoriga,
To whom?
to the relative of the lordship petitioner.
Hmm.
But this is not
WT,
the-
WTM is, the WT message is quite elaborate.
Yes, quite elaborate,
Mm.
but the facts, entire facts has been reflected,
Hmm.
and your lordship may kindly come to page 19, last 2-3 lines.
Hmm.
Why there that there is possibility of responding to it.
Oh,
and
that line they have added, that may be a reason of this thing.
Yes.
But all other things are ground.
Yes, and secondly, lordship, his family members regarding his arrest and kindly explain the same.
No, it
Okay.
will be difficult, mister.
My lord, this is in English, lordship, but so far, lordship, Mihir Ranjan Shah is concerned that lordship, the judgment of the Honorable Supreme Court, lordship, it should be in vernacular language, it should be written in vernacular language.
Vernacular language to whom?
Vernacular language to the arrestee.
Hmm?
The arrestee was not served. Yeah. Since lordship, apart from the merit of this case, lordship, this is second ground my second ground, lordship, this is no notice under section 47 as served.
Ground of arrest to whom? To the wife, family member.
Wife was also arrested.
Hmm.
My lord,
No, vernacular medium to whom?
whom to the petition, arrestee, lordship.
Where? Have you given in document? Where?
No, that was not given. That was not given.
No, what is it?
Only this WT message has been given to the relative
Huh,
of the arrestee.
correct.
But arrestee was not given any notice.
Section 50 notice was not given.
No.
Hmm?
No.
Grounds of arrest was not given to
It's
you.
not given. That is the ground, lordship.
Yes, Sharma, have you checked? You check. He's saying that like section 47 notice is not given. CDS come.
Also, I tender my apologies.
Hmm?
I tender my apology for not being able to appear before when the matter was called for.
No problem.
In fact, your lordship, the last order may be paid. The last order was passed based on an observation that is at page 27, lordship, by the court below.
Mr. R. Islam is appearing. R. Islam, correspondent number 2. I think he said he has instructions to withdraw.
In fact, lordship, I had placed before lordship last time also, the certified copy. I just want to peruse that.
What is that?
That application that was preferred by personally appearing before the court below by the informant. And at page 27, lordship, that is relevant.
Mr. Sharma? Because there is an, application filed before the district and session judge, not objecting to the bail. They are saying there's some extraneous this thing and all. And today also, you can see the, this thing, we'll allow him. Heard Mr. P.S. Dakar, learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting PRS bail to the accused applicant in connection with Chanmari PS case number 48/2026 under sections 64 bracket 1 stroke 127 bracket 2 stroke 35351 bracket 3 of BNS 2023. One FIR dated 3/5/2026 was lodged before the officer in charge Chanmari police station, Gauhati, Gauhati. Why don't you write what is there in the FIR? Why don't you write what are those allegations in the FIR?
Yes, I have written.
Where you have given? Para 3.
There are 3, it starts from para 3.
From the very beginning, you started denying, saying that I'm not involved, I'm not this, I'm not that. But you didn't write anything about what is the allegations there.
I've given statement.
An affair was lost to so. Alleging internally that the accused person is a married man and have a child. Semicolon that on 31/3/2026 at around 2:30 afternoon, he informed the informant over telephone that she should help out his deceased son. And after hearing the news, when the informant went to the house of the accused person, he came from backside and forcefully raped her and threatened to kill her. Who has translated this, Mr. Chetri? Huh? Who has translated this FIR? Mr. Chetri has done it?
Anyway, I take responsibility.
How come your translation has become so poor? Mr. Chetri. Okay, right, raped her and threatened her that she would be killed if she informs about the incident to someone. On receipt of the FIR, Chanmari Police Station case number 48/2026 under the aforementioned sections was registered. The learned counsel appearing for the accused applicant submits that in fact the accused applicant and the informant are the neighbors. They're neighbors.
Yes, neighbors.
They are neighbors, and due to certain misunderstanding and miscommunication and external influence, the informant had filed the FIR. He further submits that the informant, after realizing the mistake, had filed an application by way of an affidavit before the learned court of additional district and session judge number 4 Kamrup Metro at Gauhati, wherein she had specifically stated that after lodging the FIR, she realized that due to certain extraneous influence, she had lodged the FIR, and she still has good relation with the accused applicant. CD in the instant case has been received and the same is perused, taking into account of the fact that that the informant has filed an application before the learned additional district session judge number 4 in anticipatory bail application number 1042026. Wherein she expressed her no objection in granting pre-arrest bail to the accused applicant, as well as also taking into account of the fact mm, only the right then taking into account this, this court is of the opinion that the accused applicant should be granted granted the privilege of pre-arrest bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Chanmari PS case number 48/2026, he shall be released on bail on furnishing of a bail bond of rupees 30,000 with security of like nature to the satisfaction of the arresting authority, subject to the following conditions: conditions within 10 days appearance, then other 2 conditions, fully cooperate in this. In terms of the aforesaid direction, the instant AB application is disposed of.
Idea.
Chapter 8 translation. Hmm? আমি এখানে ডিলে করব।
Just now I had very conclusive. That proof is not. The sharp or not lawsuit, that is not known.
President Saab,
Just now, lordship, after observing that, lordship, I consulted with the client. Lordship, they are saying that no document was sharp.
your client will say so, but we'll go by this.
Yes, that particular lordship. Very exciting, your lordship, and very lordship, because just it has been submitted on 26 lordship on 17/6/2006, 26. Already your lordship 123 days behind the bar. That's what
Serious allegations and there are materials against you.
this person has not done anything. Only his offense is that lordship, he has given the shelter. Both the parties, victim as well as the lordship.
Heard Mr. M. Khan, the learned counsel, appearing for the accused applicants. Also heard Mr. B. Sharma, learned APP for the state. APP for the state. There is an application under section, you write this, huh? Application under section so and so so and so. And then you write. The gist of the facts leading to filing of the instant bail application is that the informant, wife of Abdul Mannan Borvia, lodged an affair alleging that on 4/3/2026 at about 3 p.m. her husband Abdul Mannan Borvia left for Guwahati along with some persons in a Scorpio vehicle, including the accused applicant. It was alleged that after reaching Guwahati, his mobile was found to be switched off and he could not be contacted. It was alleged that in this regard, in this regard, a missing entry was earlier lodged in Kalyan police station. Subsequently, the complainant received a phone call from mobile number 8974916230, wherein the caller demanded a ransom of rupees 10 lakhs for release of her husband. In view of the aforesaid FIR, the police registered the PRC. Police registered Kalayan PS case number 28/2026 under the aforementioned sections, and thereafter after filing of the charge sheet, the matter is pending for framing of charge. Framing of charge.
Accused number 1 is absconding. Take time for lordship. Accused number 1 is absconding.
Who is accused number 1?
Accused number 1 lordship, one Afsar Hussain Borwe, he is the main person.
Okay, if he's your friend, just give him a call. Tell him that you come back. That trial, we should finish the trial as soon as possible. That is the best way to do it. Why don't you do that? Is it not? He is your friend. You just give him a phone call. Say that like because of your absconding, because of you, the trial will take long time. So you please come back and join the trial, and it will be completed. That is the best way to do it. You do that. Because otherwise, if you say that like if somebody is absconding, trial will take long time, that's why give me bail. This court is not going to give bail on those grounds. So better call your absconding guy. Pending charge, okay? Then you write the learned counsel appearing for the accused applicant submits that the accused applicant number 2 has already been granted bail. Granted bail by a coordinate bench of this court. He submits that the accused applicant number 1 is no way involved in the instant case, and in fact he has been wrongly implicated in the the case. He further submits that what is the time of this thing?
For 123 days.
Submits that he is already behind the bars for 123 days, and since charge is yet to be framed, the trial, the completion of the trial will take a long time. Therefore, taking into that account, the accused applicant should be granted bail. The scan copy of the TCR has been received and the same is perused. Full stop. Taking into account the materials available in the TCR and of the fact that charge is yet to be framed in the instant case, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
51.
May I please, my lord? May I please, my lord? The petitioner number 3 was granted interim bail by order dated 26. Petitioner number 3 was granted interim bail, my lord, By order dated 26/6/2026, my lord, and pursuant to that petitioner number 3 appeared before the IO and so recorded his statement and furnished bail bond also. So the case is that, my lord, the informant is the wife of the petitioner number 1 and daughter-in-law of the petitioner number and sister-in-law of the petitioner number 3. Man. The FIR is at page 14. Man. Yes. Who has been granted granted interest? Only 3. Mm, 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 mm. Matrimonial, this thing, let them go. Heard Mr. S.K. Senior, a learned counsel appearing for the accused applicants, also heard Mr. K. Bishop, the learned AP for the state. This is an application under 482 BNSS, praying for pre-arrest bail to the accused applicants in connection with dispute PS case number 388/2026 registered under section 85/89/3 of BNS 2023. An FIR dated 14/6/2026 was lodged by the wife of the petitioner of accused applicant number 1, was married to the accused applicant on 22/1/2026. It was alleged that subsequently she got pregnant, but petitioner number 1 refused to take responsibility and but it was not without consent. First this thing. It was with consent. And there is a WhatsApp chat. Taking responsibility and after taking to speak to administrative medicine, which led to miscarriage. The allegations were there are certain allegations against the husband and wife as well. A coordinate bench of this court, by order dated 26/6/2026, granted interim pre-arrest bail to the accused applicant number 3. The case diary in the instant case has been received and the same is perused. Taking into account the interfacts of the case and statements made before the investigating officer, this court is prima facie of the opinion that the accused applicants should be granted interim granted pre-arrest bail. Accordingly, it is directed that in the event of arrest of accused applicant number 1 and 2, they shall be granted, they shall be released on bail on punishing of bail bond of rupees 20,000 each with surety of like nature to the satisfaction of the arresting authority, subject to the condition that the accused applicants shall appear before the investigating authority within a period of 10 days from today, and also cooperate with the investigation by making themselves available as and when called for by the investigating officer. Full stop. In respect of accused applicant number 3, 3, the interim pre-arrest bail granted to Tuturava is a lady.
No, my lord.
Huh?
Gents, my lord.
Who is he?
He's the, my lord, brother of the
Okay.
petitioner number.
Accused number 3 is made absolute. Is made absolute. Full stop. In terms of the aforesaid directions, the instant application is disposed of.
53.
CD has come.
Place your lordship. Senior learned counsel is out of station. Kindly adjourn the matter for today.
Notice served. Okay. Heard miss, your name?
Begum Shajida.
Begum Sajida, learned counsel appearing for the accused applicant. Also heard Mr. K. Boisho, learned AP for the state. Mr. K. Boisho submits that service of notice upon respondent number 2 has already been completed. In the aforesaid completed. He has submitted a report to that extent before this court, and the same is marked X and kept on the file. Let the matter be listed.
I look short date given. if
Let the
possible.
matter be listed on fourth. Retain the CD till then CD shall be retained. Let see the next date. It is very recently it has been served. Notice. Record is come. CD not received. Okay, CD heard Mr. M. Khan, the line counsel for the accused applicant. And we also heard K. Vishal and APE for the state. CD not received, let the matter be listed on 5th July.
May I please your lordship? So this is some lordship, a small quarrel between the complainant and the petitioner number 2. Over a pumpkin tree on the
Over a
pumpkin.
Over a what?
Over a pumpkin plant. And this is the FIR case number 11.
Heard Mr. Your name is what? Jugaria?
Yes, sir.
Yes, Hussein, the learned counsel appearing for the accused applicant also. Wait, learned counsel appearing for the accused applicant also heard, CD has come. Also heard Mr. K. Boisho, learned APV for the state. This is an application under section 482 of VNSS. VNSS praying for grant of bail to the accused applicants in connection with Juria PS case number 134/2026. which was registered under sections 118(2) and 3(5) of BNS 2023. An FIR was lodged on 26/5/2023, alleging that on 19/5/2026 at 11 a.m., a quarrel took place between the informant and the accused applicants regarding a pumpkin plant standing on the bank of a pond. And during the quarrel, the complainant got injured and had a fracture. In view of next para, in view of the aforesaid FIR, the FIR police registered Juria PS case number 134/2026. Full stop. Case diary. Full stop. Then they were taking this the case, though the case diary was called for, the case diary is yet to be received. Taking into account the allegations made in the FIR as well as submissions made by the counsel appearing to the respective parties, this court is of the opinion that the instant in the prayer for PRS bail should be granted to the accused applicants. Accordingly, it is directed that in the event of arrest of the accused applicants in connection with Juria PS case number 134/2026, the accused applicants shall be granted bail on furnishing of bail bond of rupees 20,000 each with the security of like nature to the satisfaction of the arresting authority, subject to the condition that the accused applicants shall cooperate with the shall appear before the investigating officer within a period of 10 days of 10 days of passing of the order today, and shall cooperate with the investigation and making themselves available before the investigating officer as and when called for. In terms of the aforesaid direction, the instant AV application is disposed of.
68, bail hearing.
Last item, bail here.
Please, Your Lordship, my lord. That this is a pre-arrest bail application, my lord. But you will find the FIR at page 11, my lord. The next one, charge sheeted matter, my lord. Charge sheeted matter. In fact, my lord, in the FIR, my lord, they have admitted the consensual relationship, my lord, and the love affair between the victim girl and the accused person, my lord. And the victim, according to the
One second,
my lord.
His name is Ashik.
Ashik, my lord.
He is doing Ashiki.
My lord. It's a love affair, my lord. They have admitted, my lord. And the girl is, my lord, as per medical report also, my lord. She is in between 18 to 19 years, my lord.
Everything is fine, consensual sex is fine, but why make video and like make viral?
But I don't know if they.
You are ditching her fate. You are ditching her. You are cheating her.
This is all along.
This is totally not acceptable.
This is all along.
You fall in love with somebody, you have some kind of relationship that is accepted. But if and you exploit her, after exploiting her physically, you exploit her morally.
This is all
and in public, making a video.
This is frivolous allegation, my lord.
Huh?
With all respect, my lord. This is
No,
not correct.
no.
In fact, my lord, regarding my lord.
No.
I'm referring to my lord 3 decisions.
You are appearing for?
My lord, lordship will kindly allow me some time, my lord. I'm referring 3 decisions of the my lord. One is apex court decision, my lord. Another is my lord 2 other decisions. My lord.
What does it say, apex court?
It says, my lord, when the relationship is consensual, my lord. And the age of the victim girl is, my lord, in between, my lord, 17 to, my lord, 16 to 17 years, my lord. She may be regarded as a consenting party, and when there is a love relationship, and if the medical report doesn't signify anything, my lord, then the bail should be considered, my lord.
Bail should be considered. We are not considering it.
Lordship, I am praying before your lordship, my lord, just to peruse this, my lord, decision, my lord. There are very small paragraphs, my lord. I'm referring it to your lordship.
Yes.
Yes, my lord. Yeah.
One is, my lord, decision of the, my lord, Honorable Supreme Court, my lord.
You tell me the paragraph, first
Yes.
one, Anas.
Last one, yes.
Hmm.
Paragraph number, my lord, in the second page, my lord,
Hmm.
third paragraph.
Hmm?
In the second page, my lord,
Hmm.
Anas, my lord,
Last paragraph.
yes.
It
the
is
third
directed that the applicant shall examine complete corporation in ensuing this. No.
Fourth
which-
paragraph, my lord.
Huh?
Sorry, my lord, the last paragraph, my lord, in the second page. Learned counsel for the appellant.
No. Where you are reading?
In the second page, my lord.
This case, Anas.
Anas, yes.
Huh.
In the second page, my lord,
Second page, yes.
last paragraph, learned counsel for the
Hmm.
appellant submitted that the allegation under section so and so of BNS as well as section 6 of POCSO Act are wholly frivolous. That in fact there was a consensual relationship. This is regarding consensual relationship, my lord.
See, protection order was issued, first of all.
Yes.
That is a different distinguishable factor.
Right.
So protection order was issued and she was cooperating. In that circumstances,
Yes.
the bail was granted.
Yes.
Huh? So it doesn't
I
have
will
any
also
relevance.
cooperate, my lord.
It doesn't have any relevance in this case.
My lord,
Then
regarding, my lord, the next one, my lord,
Hmm.
this is, my lord, the
Which
passed by the
para-
honorable, my lord, that yes.
Yes,
the,
which
my lord,
paragraph?
Karnataka High Court, my lord.
Which paragraph?
In the third page, my lord, paragraph number 4, my lord.
Third page, paragraph number 4.
Yes.
Okay, learned counsel.
Start from paragraph number 4.
That is about
Everything has been detailed.
17 to 17 years, 9 months, and her date of birth is
Paragraph
so-and-so.
4 to 8, my lord.
And she was in love with her so-and-so. Then,
Covers my case, my lord. Squarely covers my case, my lord.
this is not applicable. Because here, first thing is that 17 years, 9 months.
Yes. my
Okay,
lord.
first thing.
Yes.
Second thing, ECC, before the police stated that there's a consensual relation.
Right.
Fine. In your case also consensual relation.
Yes.
That was the parity you want to bring. But in your case, addition to that, there is a allegation of making her, video viral. So that allegation is not there in this
This
case.
is all, my lord, frivolous.
He's a married person.
There is no bar, my lord. He is a Muhammadan, my lord. Otherwise, my lord. Regarding that aspect, my lord, there cannot be a bar, my lord. That a man cannot, my lord.
Anyway, other things like there are Mr. Hamad. Mr. Hamad, I am saying you that there are the materials available in the in this CD does not allow the conscience of this court to allow you bail at this moment.
But I'm humbly
So
praying
if you
before your
press
lordship.
on also you will not get it. If you not press also you will not get it. If you press more, then your conduct will not be.
But otherwise, my lord, I will not hamper with the trial, my lord.
No,
This is my
that's a different thing. But at this
an
stage, no.
observation may kindly be
At
made.
this
my lord.
stage, no.
Possible.
Heard Mr. J. Hamad, the learned counsel appearing for the accused applicant. Also heard Mr. B. B. Sharma, the learned APB for the state, as well as Mr. B. Dr. the learned counsel appearing for the informant.
May I submit
Informant. Now, what is your submission?
My lord, lordship will kindly see the
Wait,
earlier
wait,
ordinance.
no, okay.
18:6, my lord. Lordship
Done,
will
done,
kindly
done,
verify.
done. Don't waste
There
time.
was, my lord,
Don't waste time.
chance
Done.
was given to
And
them
this is
to
an
file the written
application
objection,
under
my lord.
section
They have not objected, my lord,
482
till
of
date.
BNSS praying for
Three
pre-arrest
times the
bail to
case
the
was
accused applicant
listed, my lord.
in connection with Juria PS case number 80/2025 under section 64 in bracket 1/351 bracket 2 BNS read with section 6 of POCSO Act. POCSO Act full stop. An FIR was lodged by the informant on 19/3/2025 alleging that her daughter, aged about 17 years, studying in class 9, was allured and trapped in love by the accused applicant for the last 6 months. It was alleged that during that time, he established physical relationship with his minor daughter and also recorded video recording of such activities, full stop. It was also alleged that that her daughter was unaware of the fact that the accused applicant was a married person, and she came to know about this fact later on. When when her daughter stopped talking to the accused applicant made the video recording viral. Full stop. In terms of the next para, in terms of the aforesaid FIR, the police registered Judea PS case number 80/2025. Full stop. Full stop. Mr. J. Hamad, the learned counsel appearing for the accused applicant, submits that the allegations are totally false, and the whatever physical relation the accused applicant had with the victim, had with the girl, is of consensual in nature. Therefore, he submits that the accused applicant should be given free arrest bail, as he is willing to cooperate with the investigation. Yes, full stop. The case diary in the instant case has been received, and the same is perused. Mr. B. Sharma, the learned APP, opposes the bail application, stating that sufficient incriminating material against the accused applicant of his involvement in the instant case. Taking into account the entire facts of the case and on perusal of the case diary, this court is not convinced, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AB application is rejected. Yes. This is TCR, not case diary, TCR. Scan copy of the TCR. Mr. Mohan, some other day?
No problem, my lord. There is an order, call for the report from the medical college as well as the forensic.
Some orders are required to pass. I mean, 2, 3, 4, 5, not 4 others have to pass bail. So some other time we'll fix it.
No, interim order that may continue.
Heard Mr. P. Mohanta, the learned counsel for the petitioners. Also heard Mr. B. Sharma, learned AP for the state, and Mr. A. Misra. Mr. On behalf of Mr. S. Das, the learned MKS QD for the respondent number 2. Let the matter be listed. When do you want, Mr. Mohanta?
August, first week of August.
Let the matter be listed in the first week of August. Till that time, the interim order passed earlier shall continue.
Yes,
You have not furnished the copy
last occasion.
for 5/6/2026.
Today I'm furnishing today. Today I'm going to furnish my today settlement.
Why it takes so much of time? Okay, Mr. Mr. A. Mateen, the learned counsel, Mr. A. Ahmed, the learned. Mr. M. Ahmed, the learned Mateen Ahmed, the learned counsel is present for the petitioner, and Mr. K. Talukdar. A. Tarabdar is present for the respondent. You are respondent, right? Mr. A. Tarabdar submits that the copy of the petition has been served on him today only. Therefore, he needs some time to prepare for the case. Accordingly, prays for 2 weeks time. 2 weeks time, let the matter be listed after 2 weeks. After 2 weeks.
State.
The question petition, absolutely frivolous FIR. This is actually a civil dispute. Lordship may see the FIR.
We will have to fix it some other day. Today it will be difficult.
The past 5 hearings, I've been traveling for this matter. If for some reason or the other it is getting adjourned, of course I bow down to your Lordship. I know your Lordship.
You're coming from
New Delhi.
New Delhi. Today, I mean, some difficulties are there.
My name is not even there in the FIR. That is, it's a very.
Correct, but like, but hearing this matter will take some time. Mr. Das, you were there. Today, it will be little bit difficult for this court to hear this matter actually. And he's also coming, I'm like, I understand your problem. No, we are not going into the merits. We are not going to the merit as of now. But will it be possible some other time? We are, I mean, we also have some.
Lordship may then have it on the 20th if possible, because there is another.
20th, do you have another matter?
Another matter on the 21st, so Lordship, I'll be here on the 20th.
So we'll fix it on 20th of August.
20th of August.
20th of August? Yeah. 20.
Let it be mentioned in the order that, because again,
No,
some difficulty may be expressed from their side, and then the matter may again.
No, they have not expressed any difficulty.
Because this has happened.
And they have not expressed any difficulty. This is only,
happened on previous.
this is only a request from the court because of some difficulties. This. The 28th, the endeavor, and we'll mention that endeavor will be taken, will be given to hear the matter, okay? That will
I'm
do?
deeply grateful.
Okay.
I'm deeply grateful.
Heard Mr. H. Agarwal.
I'm Ishan Chaya. My name is mentioned in the last order. 18th June.
Okay. Heard Mr.
I Chaya.
M. Chaya.
I Chaya.
M or?
I.
I Chaya. It was wrongly written at M. Chaya.
Oh.
Okay, heard Mr. I Chaya, the learned counsel appearing for the petitioner. Also heard Mr. D Das, the learned senior counsel, assisted by Mr. K. Mohammed for respondent number 2. Respondent number 2. Respondent number 2. And anybody else is appearing? Who is it? You are appearing, you are there. Mr. B. Sharma is appearing for Mr. B. Sharma, the learned APP for the state. Let the matter be listed on 20th of August, and endeavor shall be given. Endeavor shall be made to hear the matter on the date. 20th of August.
I'm deeply.
17.
Not criminal petition seeking postponement of the FIR.
Heard Mr. MK. We are giving some time. Heard Mr. MK Das, the learned counsel, appearing for the petitioner.
My lordship, my only problem is there is no interim in this matter. That is.
Okay, we'll give a short date. MK Das, the learned counsel appearing for the petitioner. Also heard B. Oja. B.S. Oja, the learned counsel appearing for the respondent. Respondent number 2. Mr. B. Sharma is present for learned APP, is present for respondent number 1. The state, the state. Mr. M.S. Oja submits that M.S. Oja prays for some time to file objection in the instant case. Let the matter be listed on 10th of August. Let the matter be listed on 10th of August.
So in the meantime.
In the meantime, the learned counsel appearing for the respondent shall positively file the objection in the instant case.
Deeply obliged.
19.
May it please your lordship, this is an appeal against conviction under section 10 of the POCSO Act. There is also an IA for suspension of sentence. Lordship may kindly issue notice to the respondent number 2 and call for TCR.
Heard your name?
P. Majumdar.
Heard Mr. P. Majumdar, the learned counsel appearing for the appellant. Appearing for the appellant. This is an appeal under section 415 in bracket 2 of the BNSS. assailing the impugned judgment and order dated 12/6/2026 passed by the learned additional session judge cum special judge of POCSO Dhubri in special POCSO case number 115/2022 arising out of Fakirganj PS case number 129/2021, whereby the appellant was convicted under section 10 of the POCSO Act 2012 and sentenced to undergo rigorous imprisonment for a period of 7 years and to pay a fine of ₹10,000, in default to undergo simple imprisonment for further period of 2 months. Let notice be issued to respondent number 2 as per the prevailing notification of Gauhati High Court. Notice to respondent number 1 is dispensed with as Mr. D.P. Goswami, the learned APP, is present for respondent number 1. Steps for
Fix a date.
There's a IA also.
Yes, Lordship.
The IA will be heard together.
Yeah,
Let's go first.
kindly fix a date, Lordship. Fix a date.
No, not fixed. The notice can go, then you write, steps for notice shall be taken by the appellant within a period of 3 days from today. Let the matter be listed after 3 weeks.
Deeply obliged, Lordship.
And I also same order will go. The IA will write applicant. IA instead of appellant, you write appellant.
20. May please, Your Lordship. Your Lordship, this matter may be taken up on any other date along with criminal petition number 507. Both arise of the same cause of action. May this matter be taken on any other day along with criminal petition number 507. Because two
Okay.
petitions with the same cause of occurrence.
Mr. T. Lascott.
T. Lascott.
T. Lascott, the learned counsel appearing for the petitioner, submits that the matter should be taken up along with
Criminal petition number 507/2026.
due to the fact that
Both the cases arise out of the same cause of occurrence.
due to the fact that both the petitions have been filed challenging the same order.
Challenging same cause of occurrence, 2 FIRs were filed.
Challenging same cause of action. Let the matter be listed after 2 weeks.
Deeply.
Please, Your Lordship. Hello, it's a quashing proceeding against 498, my lord, 498, pending for the additional CZM Kamrup Metro, my lord. In the last occasion, my lord, TCR has received, my lord, but without the statements of the, my lord, witnesses and all, my lord. Now it is received, I checked the record.
Okay.
TCR second file.
Okay, we'll put it on some other day. When?
The month of August, any date, my lord.
Okay, heard Mr. S.
My
Hazarika.
lord.
S. Hazarika, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned APP for the state, and Ms. R.B. Boda, the learned legal aid counsel for respondent number 2. TCR in the instant case has been received. Along with what?
My lord, TCR 2 files has been, earlier 1 file has been received, now TCR 2 files has received.
Complete TCR has been,
Complete TCR.
complete TCR. Scan copy of the complete TCR, scan copy or what?
Scan copy, scan
Scan
copy.
copy of the complete TCR has been received. Let the matter be fixed in the month of August for usual course for hearing.
Well, there is an interim order, man.
Interim order so passed earlier shall continue till the next date of listing.
I'm deeply of this. Hello, if convenient, can it be a date, maybe fix, my lord?
It's fine. I mean, we have already
The
passed
month
in the
of-
month of August,
Last week, if possible.
in the last week of August. In the last week of August, on a date to be fixed by the registry.
Oblige. Item 60, orders.
In this case, my the IA is for my suspension of sentence, lordship, the applicant appellant is my lord in.
Some other day, when?
Yeah, that may be fixed, lordship, or that, my lord.
Okay. Or
What we
Mr.
can say is in there.
M.H. Ahmed, the learned counsel appearing for the accused applicant, appearing for the applicant, also heard. So, MH Ahmed, then write DP Goswami for the EPP. Let the matter be fixed on 4th of July.
August loss.
Huh?
It will be August loss.
Sorry, for 4th August.
Loss?
4th August. Let the matter be fixed on 4th August.
How like
TCR has been received, you right? TCR has been received.
My lord, on the last occasion, TCR was called for, my lord.
TCR has come?
Not TCR.
TCR is yet to be received. Mr. A. Khan is present for the petitioner. Petitioner and DP Goswami for the state. Let the matter be listed on the second week of July. On the second week of July.
My lord, the interim may kindly be continued.
Interim order so passed earlier shall continue till the next date of listing.
My lord, obliged.
Last application that this year is called for.
TCR is come. Ms. H.M. Fukon is present for the petitioner. Mr. DP Goswami and APP for the state is present. TCR is yet to be received. Service of notice is also not there. You may be required to take fresh steps, it seems. Notice hasn't been served, or you take some, you take some instructions. Mr. DP Goswami, the learned APP, to take instructions as regards service of notice on respondent number 2. Let the matter be fixed. Let the matter be fixed in the 3rd week of August.
Specific date.
Let the matter be fixed on 18th August. 18th August.
This case TCR is received, my lord, and notice was sent to the PP office.
Service of notice completed.
POCSO matter, man.
When it was completed? 13/7. Heard Mr. A.K. Gupta, the learned counsel appearing for the appellant. Also heard Mr. D.P. Goswami, learned APP for the state. Mr. D.P. Goswami submits the service upon respondent number 2 has been completed on 13/7/2026. However, when the matter was called for, now none appeared for the respondent number 2. We'll give one more date.
Well, Lordship may appoint a amicus.
Because 13/7 only, some dates sometimes should be, otherwise the purpose of giving notice doesn't fulfills.
So Lordship may appoint a amicus, my lord.
What I am saying is that some time should be granted to a person to engage somebody, isn't it? If you, only 13 they've received the notice. Today is what, 23? 22. Only 1 week has gone over. So some time should be granted. Otherwise, what is the purpose of serving notice if you do not give any time to them? Correct? So you have to be reasonable. Let the matter be listed on 6th of July. By 6th of July, nobody comes. Then I will engage somebody. Let the matter be listed on 6th August 2026. If you serve the notice today and tomorrow the matter is listed and nobody appears and we engage in amicus, then he may come and say that like I was not given any time and court is appointed in amicus. What is this RA for? How many days?
197 days. Yeah, we have taken stage.
Respondent number 2.
Professional manner average service. We must show for the manner.
Notice is served, Mr. Goswami.
The 9th of June. Registers.
This is what POCSO matter or what?
No, madam. Madam, so far, imprisonment is 1 year, madam. For 1 year imprisonment has been, my lord, imposed, my lord, for offense, commission of offense under section 364A, and 1 month for section 341, my lord. Already, my lord, 1 month, more than 1 month he has behind the bar, my lord. So only 1 year, my lord, is an excellent period of.
Okay, heard Mr. M. Sharma. We are condoning it. I mean, this is delivered. Nobody is appearing. Heard Mr. M. Sharma, the learned counsel, appearing for the applicant. This is an applicant. Also heard Mr. D.P. Goswami, learned AP for the say. This is an application under section 5 of the Limitation Act 1963, paying for condonation of delay of 197 days in filing the criminal revision petition against the judgment and order dated 22/8/2025, passed by the learned additional session judge Udalguri in criminal appeal number 21/2024, arising out of the judgment and order dated 2/8/2024, passed by the learned SDJM in bracket S Udalguri in PRC number 566/2022, whereby the findings and sentence passed by the learned trial court has been affirmed. What was the sentence?
The sentence was, my lord,
And okay, forget about this. Where is your explanation?
paragraph number 1, my lord.
Hmm?
Paragraph number 1 of my IM.
Not one, maybe two.
Two is also, yeah, my lord. 1 is also, my lord. So far, that part is, may I read you?
Judgment and order was passed on 2/8.
My lord, 2/8/24, passed with the learned SDJM.
And the petitioner intimated his counsel.
My lord, consent on my 2/9/2020.
What about this? What happened to, I mean, what happened for this period?
So far, that.
No, it cannot be condoned. There is no explanation.
Paragraph 2 I have managed explained.
Paragraph 2 is said that the petitioner begs to state that the earlier counsel engaged by the petitioner have conducted appeal.
Right.
So and so, fine. The petitioner intimated counsel on 2/9/2025.
Right.
On that day, he came to know that appeal was dismissed.
Right.
By the who? Petitioner intimated his counsel.
My lord,
Or counsel intimated the petitioner. What?
duty is to, my lord, to intimate, to take, my lord, the information from the counsel.
See, judgment was passed on 2/8/2024.
My lord.
Then on 9/2/2025, who has intimated whom?
Petitioner.
Petitioner intimated the counsel. So what have you been doing from 2/8/2024 to 2/9/2025?
My lord, so far, that explanation is, my lord, concerned, my lord.
Day-to-day explanation is required.
That is.
So where is that?
That is not there, my lord.
Then I mean, how can it can be considered?
Because, my lord, only, my lord, what happened, my lord, the so far.
No, I mean, how it can be considered then? I mean, if you don't have any right to file this petition, it is not a statutory right. I mean, if you are filing it, then you'll have to, explain the delay.
Lordship is correct.
Explain the delay.
Explanation has to be there, my lord.
And then we'll wait for some time whether somebody comes. Otherwise, I'll dismiss this.
Then, my lord, I may be allowed to file additional evidence. Additional affidavit to explain the day-to-day.
I explain it. Let them file. Mr. M. Sharma, learned counsel appearing for the applicant submits that he should be allowed to file an additional affidavit in the instant IA to bring on record certain material facts, also which is not objected by the learned APP appearing for the state. The notice upon respondent number 2. Right. Office note dated 16/7/2026 reveals that neither AD card nor any unserved notice in respect of the respondent number 2 has been received by the section till date. Let the matter be listed after 2 weeks.
Let it be on, my lord, 4th of August, my lord.
No, 4th of August, no.
Because, my lord, on 29th, my lord, notice has been received, my lord, by the respondent number 2. Meanwhile, I will file the additional letter. Because he is behind the but again, my lord, for 1 year, my lord, he has been in. That's why.
Now, this doesn't reveal that it was delivered to whom, which tracking number, consignment. How do you know?
Consignment report, my lord, reflects as such.
We do not know anything.
Because in such manner report they did not mention
Okay, next day it will be considered. Let the matter be fixed on 5th July.
5th of August.
5th of August.
I'll apply your.
May I please Lordship here, I'm appearing on behalf of S. Biswas. The service is completed and Lordship may kindly fix for hearing on.
Service upon respondent number 2 is complete. I is for what?
Support.
I
is for condonation of delay, Lordship, for 66 days.
I for
Condonation of delay, Lordship,
how many days?
66.
66 days. Okay, let the matter be fixed on 5th of August.
Lordship, may I kindly fix on 14 of August and kindly call for TCR, Lordship.
Why TCR is regards to delay condonation? I am not condoning delay without the other person. Notice is served, but nobody has appeared. And when was it served?
It's on 23/6. Lordship, the delay condonation is already disposed.
Oh no, I mean, from where are you saying notice is served?
Lordship,
From where are you saying that notice has been served?
so we in a office,
Hmm?
we have seen the office
Office note doesn't say notice is served.
received, notice was received.
Hmm?
Notice has received.
No, the section has received the notice. Section has issued notice, but where is the office report that has been noticed? Service report is still service report of service report regarding service of notice upon respondent number 2 is still awaited. Let the matter be listed on. After 2 weeks.
May I kindly fix the date?
Let the matter be listed on 14th of. Let the matter be listed on. Okay, 14th of July, for August, as you have prayed. 14th of August. Okay. It is.